ನೀನು ಬಂತಲ್ಲ ಇದೆಲ್ಲಿದೆ ರೀ ಇದು ಮ್ಯೂಟ್
being spoken to, my lord, being spoken to, my lord, surfacey matter, the second highest bidder, your lordships had allowed the petition of the borrower. After pronouncement, my lord, I had made a request that it may be kept in abeyance for a few weeks. I understood, my lord, your lordships had granted that request, but orderly adu bandilla. ಅದು ನಾವು ಅಪ್ಲೈ ಮಾಡಿದ್ವಿ ಆರ್ಡರ್ ಶೀಟು ಬಂದಿಲ್ಲ. Please. Please.
Lordship's kind permission. Matter pertains to Karnataka land grabbing prohibition, wherein the order of taking cognizance by the Honorable Court has been challenged. Swami, it's in March 3rd and 3rd. So that is what I mentioned. March 3rd and 3rd. It will be taken up tomorrow, your lords.
Tax on tax, we did like this way. So tax on tax is permissible within the constitutional part. Provided both taxes are variable by the same things. That way we don't find. We could not find more on that. But somewhere I read in the fourth edition of CY of this, but I could not go to that sentence. So we have went that way. If you already did we will remain the matter for consideration because on that invoice, etc. Although that we will not consider because it is the factual old course. Since we demanding, we said that even that aspect should be considered. But we are sending it back to
Grateful. I'm deeply.
in order to the maximum which were there.
Let's go to the main.
Main of the tribunal for consideration afresh in the light of the observations herein above made and in accordance with law. This remand would be decided within an outer limit of 3 months and after giving an opportunity of hearing to the stakeholders. What's made easy? We have just appreciated both the sides.
Deeply grateful.
Yes, sir.
For 2 weeks time. Senior has been engaged, some medical emergency in the family, he had to go to the hospital. Hence, my lord, 2 weeks, maybe posted for final hearing on the next occasion.
2013, 12 ವರ್ಷ ಆಗಿದೆ.
No, my lord, next occasion definitely will complete, my lord, I've been told.
ಈಗ ಎಷ್ಟು ಸರಿ ಅಜರ್ನಾಗಿತ್ತು ಕೊಡಿ ನೋಡ್ತೇವೆ ನೋಡಿ ಗೊತ್ತಿಲ್ಲ 2013 ಮ್ಯಾಟರ್ ಅಲ್ಲ. People should not pelt stones at our cars
Medical emergency.
when we go out. Yes. ಮುಂದೆನೆ 2 ಸರಿ ಆಗಿತ್ತು. ಅವಾಗ ಯಾವ ಗ್ರೌಂಡ್?
Only for medical emergency, my lord. Maybe take it up next week or the week after, my lord. Definitely week after.
ಯಾರು ಶಂಕರ್?
Shankar, some.
ಇಂತ ಬರೀ ಬಿಗಿಯಾದ ಗ್ರೌಂಡ್ ಹೇಳ್ಬಿಡ್ತೀರಿ, ನಾವಿಲ್ಲ ಅನ್ಲಿಕ್ಕೆ ಬರಲ್ಲ. All this matter is reluctantly adjourned. This old matter is reluctantly adjourned by 2 weeks on the request of counsel appearing for the assessee. All right. On health ground of the arguing counsel. Okay.
This is the matter that your lordship has been hearing for the past month. Request to pass over.
Huh?
This is a company matter, my lord.
Huh.
Misappropriation and oppression. That your lordship has been hearing senior counsel, Mr. Naganand is appearing.
Correct.
Pass over. my lord.
Pass.
Number 4, because you already.
Needful will be done in the course of the day.
Needful to be done in the course of day. Yes, failing which heavy costs may be levied on the next date of hearing. Next date of posting. Okay.
Number 5, yes, Sammati.
Lordship, I'm filing the better affidavit today, my lord. I may be permitted to take out notice, my lord. Today I'm filing it. Notice ಹೋಗ್ಬೇಕು.
Emergent notice.
Number 6, Sammati, Sammai Rajkumar.
Lordship, today I'm filing the better affidavit.
Call next week for filing better affidavit. 455 days ಇದೆ. ಅಲ್ಲ at least 200 rupees per day thing which are ಮಾಡ್ತಾ ಇದ್ದೇವೆ ನಾವು. Anyway, we'll look into. Yes.
Number 7, Sammati, Sammai Rajkumar.
Lordship, 517 days today, my lord.
Huh.
It may be called along with 683 of 23 and 681 of 23, my lord. There are another two connected matters, my lord.
Call along with. ಬರ್ಕೊಡಿ.
Please.
Yes. Better. Yes. Better affidavit to you. Yes.
Number 8, Janata is gone.
Petition. My lord, 2 days time may be granted, my lord.
3 ಸರಿ ಮಾಡಿಲ್ಲ.
My lord, only
ಹಾ.
minor.
ಒಂದು ಒಳ್ಳೆ ಪುಸ್ತಕ ಕೊಡಿ. Give good book to the library. ಯಾವ್ದನ್ ಕೊಡಿ.
Please.
ಹೇಳಿ ನೀವ್ ಹೇಳಿ. ನಿಮ್ಗೆ ಹೇಳಿದ್ರೆ ನಮ್ಗೆ ಗೊತ್ತಾಗ್ತದೆ. ಹಿಂಗ್ ಕೇಳಿದ್ವಪ್ಪ, he said such a good book ಅಂತ ನಾನು ಹೋಗಿ I will mention it to my brother judges at the lunch table. Otherwise I'll say we told him like this and he stood like rock of Gibraltar, like a mute sphinx. So tell book. ಒಂದ್ 5-6 ಪುಸ್ತಕ ಹೇಳಿ ನೋಡ ನಿಮ್ ಜೀವನದಲ್ಲಿ ಓದಿದ್ದು. ಓದ್ಲಿದ್ರೆ ಮತ್ತೆ ಯಾಕಪ್ಪ ಲಾಯರ್ಕಿ ಯಾಕೆ ಬೇಕಪ್ಪ? ಓದು ಒಂದು ಸಾರಸ್ವತ ಲೋಕ ಇದು. ಲಾಯರ್ಕಿ ಅಂತಂದ್ರೆ ಹೊಲ ಹೊಡೆಯೋದಲ್ಲ ಅಲ್ವಾ? ಓದು ಬರಹದ ಫೀಲ್ಡ್ ಇದು. Tell 3-4 books which you have read, which you have heard.
Law books, my lord.
Huh?
Law books.
ಆಯ್ತು, ಲಾ, ಲಿಟ್ರೇಚರ್, ಫಿಲಾಸಫಿ, ಸಾಲಜಿ, ಎಕನಾಮಿಕ್ಸು, ಹಿಸ್ಟ್ರಿ, ಸೋಷಿಯಾಲಜಿ, ಪೊಲಿಟಿಕಲ್ ಸೈನ್ಸು, ಎಸ್ಥೆಟಿಕ್ಸು, ವಿಚ್ ಎವರ್. ಯಾವ್ದು? ಜಾಬಾಲ.
Cooperative societies.
Huh?
Cooperative societies acts will be.
ಕೋಆಪರೇಟಿವ್ ಸೊಸೈಟೀಸ್ ಆಕ್ಟ್. ಅದೇ ಕ್ಲಾಸಿಕ್ಸ್ ಯಾವ್ದಾರ ಕೊಡ್ಬೇಕು. ಪೇಟನ್ ಆನ್ ಜುರಿಸ್ಪ್ರುಡೆನ್ಸ್ ಕೊಡ್ಬೇಕು. 2 weeks granted, subject to presenting patent on jurisprudence to High Court Library. ಎಲ್ಲ ಗೊತ್ತಿರ್ಬೇಕು ಲಾಯರ್ಸಿಗೆ.
Please.
No, learning lawದಲ್ಲಿ he has enlisted the books which lawyers are supposed to read. They can't just read 2 sections and go away. See the books cited in Keshwananda. A truckload of books were cited. Many of them did not relate to law at all. ಅಂತೆಲ್ಲ ಓದ್ಕೋಬೇಕು. Otherwise cattle trespass case ಅಲ್ಲ ಇವು. ನೋಡಿ.
Hearing number 9, Sammati, Deepan Patel.
This is Supreme Court remand matter, my lord. I have filed application for amendment of the appeal memo, my lord. It was filed before the remand itself, my lord. The
Amendment.
pendency of the main appeal, my lord.
Ah.
It was filed earlier. It may kindly be allowed, my lord.
It's
Additional
Justice
ground-
Sujata's judgment.
Yes, my lord. Additional ground and substantial question of law, my lord.
ಅದನ್ನು you can raise when matter is taken up for hearing.
But it was filed earlier, my lord. 2017.
Otherwise also,
Yes, my lord.
section provides,
Yes.
it is on par with section 100 of CPC.
Yes.
You can raise other questions also. Now you have raised your other questions now.
Yes, my lord.
That you could have done at the hearing time anta. Anyway, application. Opponent ಯಾರು?
Shrikant Patel.
Shrikant Patil. Record. Revenue has moved application in IA-1 of 2018 seeking amendment of the appeal memo by raising additional grounds and substantial questions of law. First off, the said questions read as under. First off, no objections are filed to the application by from the side of assessee. First, next one, in view of the above, the said questions shall be treated as arising in the subject appeal on which both the sides can make submission when the matter is taken up for hearing. First, okay.
I may be permitted to file amended appeal memo.
Amended appeal memo, all right. Amended appeal memo to be filed after serving a copy on the other side. Okay. Within 2 weeks. Yes.
My lord, appearing for the respondent.
Your Lordship, I have raised the three, the questions of lot, but six, not.
Six, not 6 days.
ಇಲ್ಲ ಡಿಸ್ಮಿಸ್ ಮಾಡ್ಬೇಕಿದೆ ಕವರ್ಡ್ ಮ್ಯಾಟರ್ ಅದಕ್ಕೆ ಕವರ್ಡ್ ಮ್ಯಾಟರ್ ಇದೆ ಅದಕ್ಕೆ
ಕವರ್ಡ್ ಇದ್ರೆ ಕವರ್ಡ್ ಹೌದಲ್ಲೋ ಅಲ್ಲಿಗೆ ಅದು ನೆಕ್ಸ್ಟ್ ಥ್ರೆಶೋಲ್ಡ್ ಆದ್ಮೇಲೆ ಅಲ್ಲಿಗೆ ಹೋಗ್ತೇವೆ ನಾವು ಕವರ್ಡ್ ನಾಟ್ ಕವರ್ಡ್ ಅಂತ
ಡಿಸ್ಪೋಸ್ ಆಗ್ಬೇಕಷ್ಟೇ ಜಸ್ಟ್ ಬಿ
ಡಿಸ್ಮಿಸ್ಡ್ ಬರ್ಕೊಳ್ಳಿ ಅಪ್ಲಿಕೇಶನ್ ಅಲೋ ಮಾಡೋಣ ಡಿಸ್ಮಿಸ್ ಅಪ್ಲಿಕೇಶನ್ in IA-1 of 2023 supported by an affidavit seeks condonation of a long delay of 606 days. 6 days. First stop. Learned counsel appearing for the assessee opposes the application, saying that delay is too long and the explanation offered is not plausible. First stop. Next paragraph. Having heard the learned counsel for the parties and having perused the appeal papers, we are of the considered view that this application be favored and delay be condoned. ಒಂದು ಯಾವ್ದಾರು ಒಂದು ಪುಸ್ತಕ ಕೊಟ್ಬಿಡಿ.
ಬೇರೆ
606 ದಿವಸ ಪೊಕೆಟ್ ಮಾಡಿ ನಾಳೆ ಇನ್ನು ಫ್ರೆಂಡ್ಸ್ ಕೇಳ್ತಾರೆ ಅವ್ರಿಗೊಂದು ಯಾಕೆ ಇವ್ರ ಮೇಲೆ ಯಾಕೆ ಇಷ್ಟು ಪ್ರೀತಿ ನಿಮ್ಗೆ ಅಂತ ಕೇಳಿ ನಾ ಏನು ಉತ್ತರ ಕೊಡ್ಬೇಕು? ನನಗೆ ಎಲ್ಲರ ಮೇಲೆ ಪ್ರೀತಿ ಇದೆ, ಅದಕ್ಕೆ ಅದೆಲ್ಲಕ್ಕಿಂತ ಹೆಚ್ಚು ಪುಸ್ತಕಗಳ ಮೇಲೆ ಪ್ರೀತಿ ಇದೆ ನಂಗೆ. ಒಂದ್ ಯಾವ್ದಾರು ಒಂದು ಬುಕ್ ಕೊಡಿ. ಯಾವ್ದು? ಗಿವ್ ದ ಬ್ಲೈಂಡ್ ವಾಚ್ ಮೇಕರ್ ಬೈ ರಿಚರ್ಡ್ ಡಾಕಿನ್ಸ್.
ನಿಲುಕಲಲ್ಲದ ಬದುಕು,
ನಿಲುಕಲ
ವಾಸುಮತಿ ಉಡುಪ ಅವ್ರದ್ದು ನಿಲುಕಲಲ್ಲದ ಬದುಕು.
ಅದೇ ಎಂತ ಚೂಸ್ ಮಾಡ್ತೀನಿ ಅಂದ್ರೆ ಕಡಿಮೆ ಪ್ರೈಸ್ ಇರೋ ಚೂಸ್ ಮಾಡಿಲ್ಲ. ಹಾ ಅಂತ ಎಷ್ಟದು ಪ್ರೈಸ್ ಎಷ್ಟಿದೆ?
ಪ್ರೈಸ್ 150 ಇರ್ಬೇಕು.
150 ಒಂದು 10 ಕೊಡಿ. ಮತ್ತೆ ಹೌದು ಇಲ್ಲಪ್ಪ ಇದನ್ನ ಕೊಡಿ ನೋಡಮ್ಮ. ದ ಬ್ಲೈಂಡ್ ವಾಚ್ ಮೇಕರ್ ಬೈ ರಿಚರ್ಡ್ ಡಾಕಿನ್ಸ್, ಒನ್ ಆಫ್ ದ ಬೆಸ್ಟ್ ಬುಕ್ಸ್. ರಿಚರ್ಡ್ ಡಾಕಿನ್ಸ್ ವಾಸ್ ರೆಕಮೆಂಡೆಡ್ ಫಾರ್ Nobel Prize. He's a God delusion, selfish gene, magic of reality, blind watchmaker. Great works. TV debate ಎಲ್ಲ ನೋಡಿ ಎಷ್ಟು ಚೆನ್ನಾಗಿ, ಮೆಹದಿ ಹಸನ್ ಜೊತೆ ಎಲ್ಲ. ಅಲ್ಲ ಕೊಡ್ರಿ ಟು ದಿ Bar Association library. Next paragraph. The subject matter of this appeal is substantially similar to the one in.
Your Lordship, question number 1 and 2 is covered in assessee's case itself, my lord.
One. ಯಾವ್ದು ಜಡ್ಜ್ಮೆಂಟ್ ಕೊಡಿ ಪ್ಲೀಸ್. In the ITA number 834 of 2018 between Principal Commissioner of Income Tax versus Messrs. Technotree Convergence Private Limited, who happens to be the respondent hearing, so far as substantial question numbers 1 and 2 are concerned. First, I will bury them.
Question number 3 is covered in other case, my lord. In
First.
case of Wipro Limited, my lord.
The question number 3.
It is referred by the tribunal in its order, my lord.
Question number 3
Wipro
is
Limited
also covered in favor of the assessee in
Wipro Limited versus
in
DTA,
ITA, in Wipro Limited versus
Deputy Commissioner of Income Tax,
Deputy Commissioner of Income Tax,
reported in 382 ITR 179.
382 ITR 179. Full stop. Next paragraph. Like cases should be treated alike is the norm obtaining in judicial process. First, despite submission, learned panel counsel is not in a position to differentiate the cases cited from the fact matrix of the case in appeal. First, next point, in view of the above, the appeal being not meritorious is liable to be dismissed and accordingly it is, costs having been made easy. Okay.
Grateful, my lord.
Yes. Anyway, 524 days.
524 days till.
ಕೊಡಿ. ನಾವು ಹಂಗೆಲ್ಲದಕ್ಕೂ ಆ ರೀತಿ ಡಿಲೇ ಕಂಡೌನ್ ಮಾಡಿಬಿಟ್ರೆ ಲಿಮಿಟೇಷನ್, ಲಾ ಆಫ್ ಲಿಮಿಟೇಷನ್ ವಿಲ್ ಕಮಿಟ್ suicide.
Your Lordship, in this case, the reason is that review petition is pending before the Supreme Court, my lord, even till today.
ಮತ್ತೆ ಬಿಡಿ, ಮತ್ತೆ ಅದಾದ್ಮೇಲೆ ಹಾಕ್ಬೇಕಿತ್ತು.
Because
So
it will
pendency
have-
is not a ground.
it will have a bearing, my lord.
But then you should have filed it after the review.
Your Lordship, may kindly adjourn it for 2 weeks, my lord. The review petition is likely to be listed, therefore 2 weeks ಆದ್ಮೇಲೆ.
ಹಂಗ್ ನೀವು ಬರೀ ಸ್ಟೇಟ್ಗೆ ನಾಳೆ ಸೂರ್ಯನಾರಾಯಣ ಎಲ್ಲ ಕೇಳ್ತಾರೆ, ವೈ ಆರ್ ಯು ಫೇವರಿಂಗ್ ಸೆಂಟ್ರಲ್ ಗವರ್ಮೆಂಟ್? ಆರ್ ಯು ಐಯಿಂಗ್ ಸಮಥಿಂಗ್ ಗುಡ್ ಇನ್ ಯುವರ್ ಫೇವರ್ ಪೋಸ್ಟ್ ರಿಟೈರ್ಮೆಂಟ್ ಅಂತ ಕೇಳಿ ಏನ್ ಹೇಳಿ ನಾನು ಉತ್ತರ? They are same, state is on par with ಎಲ್ಲ ಸಿಟಿಜನ್ ಸ್ಟೇಟ್ ಒಂದೇ. That is the beauty of our.
ಅದರ ಒಳ್ಳೆ ಬುಕ್ ಕೊಡ್ತೀನಿ ಇದ್ರಲ್ಲಿ. ಅದರ
ಒಳ್ಳೆ ಬುಕ್ ಕೊಡೋದಾಯ್ತು ಇದಕ್ಕೆ. ಅವರು ಒಳ್ಳೆ ಪುಸ್ತಕ ಇಸ್ಕೊತೀನಮ್ಮ ಅವನು. ಟೇಕ್ ಒನ್ ಗುಡ್ ಬುಕ್.
I leave it to my lords.
ಆ ಪುಸ್ತಕನ
ಅಲ್ಲ.
Appeal is filed with a long delay of 524 days. First, an application supported by an affidavit accompanies the appeal memo. First, learned counsel appearing for the assessee vehemently opposes the application, contending that delay is too long and the explanation offered for it is not plausible. First, having heard the learned counsel for the parties and having perused the appeal papers, we are of the considered view that in the governmental process, government being always tardy, delay needs to be condoned so that the revenue would not suffer prejudice because of the culpability of the officers. First off, the explanation offered for the delay proved is also plausible. First off, the condonation of delay would not add merits to the case against to the prejudice of the assessee. First off, we also note that much older cases are pending, languishing in the court cupboards. First off, in view of the above, delay is condoned, application is allowed and delay is condoned, subject to the condition that the revenue shall submit God Delusion by Richard Dawkins, one of the finest books. The book is written with the atheist angle, but just see that. Two, High Court library, Advocates Library, all right. And one book too, madam, that you also read. You come from science background? Not in from science background?
No.
Okay. A great scholar in England who was serving in church, after reading God Delusion, he became atheist and returned from the holy orders. That is the effect of that book. By God Delusion, by Richard Dawkins, one of the great evolutionary biologists of the country. He said he's a reincarnate of Darwin. Just Google nella nodkolli yav reeti ide. Yes.
Number 12, Sanmati. 106 days now.
106 days. All.
Lordship, transfer pricing issues are involved. Question number 1 to 10 may be admitted.
1 to 10. Ale, noted. So and so. Okay.
But 13 to 15, arrange which one?
All these matters, notice has to be issued. Emergency.
Emergent notice.
Number 16, Vinod Ramana. Adi Narayana.
Yes. Ah,
I request a week's accommodation.
wait. All 2 weeks.
Interim order may kindly be extended.
Interim order to continue for 2 weeks only.
Please.
2 weeks at the request of, finally.
Please.
Interim order to continue only for 2 weeks. Okay.
Please.
Ah,
Represent the respondent 4 to 6.
ಯಾರು 4 to 6
I am the purchaser, bona fide purchaser.
action buyer.
Property from the third respondent.
Okay.
The second respondent of the
Bank.
You are from the bank.
bank.
Okay.
Because auction.
Ah.
Auction in the name of the second respondent.
Ah.
Second
I
respondent.
had 3 for impleading ಯಾರು?
I had 5 for impleading 4, 5 and 6.
Who 4, 5, 6,
I represent them. I represent.
4, 5, 6. They are the buyers of the auction buyers. They are necessary parties.
Bona fide purchaser.
No,
we purchase
I have filed objection to the,
Necessary party.
no,
Therefore,
proposed
you are a
R,
necessary-
I have filed objection to the proposed R3.
Yes.
Her presence is not required in this case because her
Why?
property was gifted to her on 7/7/2023
Yes.
and subsequently she has sold to proposal 3 and 4 on 22/7/2023. 20.
ಅವ್ರೇನೋ ಮಾರಿಬಿಟ್ಟದಂತಲ್ಲ ಈಗಾಗಲೇ ಇನ್ನೊಬ್ರು
He is representing the person.
Representing the purchaser.
purchasers you are representing.
No.
For 2 was
So
the
she has no subsisting interest as of today.
You may not have subsisting interest, but Supreme Court said, even after sale, you have certain duties and liabilities under section 54 and 55 of the Transfer of Property Act.
Only-
For vacating the interim order.
ಮೊದ್ಲಿಗೆ ನಿಮ್ನ ಇಂಪ್ಲೀಟ್ ಮಾಡ್ಕೋಬೇಕು.
My lord, in this case, only question is involved whether tribunal has power to condone the delay in filing section 17 of the appellate act, that nothing else, nothing more.
ಅವ್ರು ಕೇಳೋಣ ಅವರೆಲ್ಲರೂ ಬೇಕಾಗ್ತಾರೆ.
ಅಲ್ಲ, ಅದು ಒಂದೇ ಪಾಯಿಂಟ್ ಅಂತ ಹೇಳ್ತಾರೆ.
ನೋಡೋಣ ಬರ್ಕೊಳ್ಳಿ. The application in ಎಷ್ಟಿದೆ application? 3 of 2024 supported by an affidavit is filed seeking impleadment of auction buyers.
No, not auction buyer, subsequent purchaser.
Subsequent purchasers.
They are not the auction.
Subsequent purchase.
Subsequent purchasers of the subject property. Full stop.
And subsequent purchasers are 3 and 4 and 5. 6 is the development.
Full stop. One of the proposed respondents happens to be the developer of the property. That is respondent number 6. Full stop. They answer the description of proper parties within the discussion in Rajia Begum versus Shahnaz Begum, AR 58 Supreme Court, so and so, comma, if not necessary parties. Full stop. Even after transferring the property, comma, the transferor will have certain statutory obligations under the provisions of section 55, 4 and 55 of the Transfer of Property Act. Full stop. Next paragraph. ಅಲ್ಲಿ ಇನ್ನೊಂದು. The impleadment would not cause any prejudice to anyone except that the cost title of the case gets little longer. Full stop. Next paragraph. In the above circumstances, application having been favored, leave is accorded to array the proposed respondents as respondent numbers
3 to 6.
3 to 6, 3, 4, 5, 6, 3 to 6. 3 to 6. First stop. Yes,
Of the urgency because my lord, I am the subsequent purchaser.
argue,
I'm ready.
argue. Which one?
Note not made.
What is the question involved? Mr. Rao, are you ready in the matter?
Yes, yes, ma'am.
All right. The cost title amend ಮಾಡಿ.
Please.
Cost title. Deponent. Office objection over. Yes.
The Debts Recovery Tribunal dismisses my application on the premise that the debts recovery. But the Debts Recovery Tribunal dismisses my application on the premise that
the DRT has no power to condone delay. Lord, I initially file a writ petition and thereafter I am relegated to the remedy of filing an appeal. My appeal also comes to be dismissed on limitation. Therefore, both the fora, that is the DRT as well as the DRAT, have ultimately rejected my plea only on the ground of limitation. I have not been heard on merits. Lord, I have prepared, my lords, a list of dates, if I can submit that.
When was the order passed which you had put in challenge before the DRT?
Please, my lords.
And under what provisions?
Please, my lords.
Your friends can have a coffee round.
Yes,
This
my
will
lords.
take some time. Yes.
Lord,
Yes.
Your Lordship, my lord, in my list of dates, please kindly come to serial number 37 in the list of dates.
You list of dates, you got list of rulings with the
Please.
37. Ah,
This is where, my lords, the learned Debts Recovery Tribunal dismisses my application.
for condonation of delay.
Please, my lords.
Is there limitation?
Lord, there is a statutory period
45 days.
of 45 days.
Maximum limitation?
45.
Lord, there, my lords, the usual language saying but not thereafter is not found. Lord, may I respectfully request your lordship to kindly-
That means even after 45 days,
Please, my lords.
there is power to condone delay. That would defeat the very intent of the parliament. We have held that way in Dharwad in matters relating to the appeals filed under the 2013 land acquisition, etc.
Please,
We have
Lords.
already held that way.
Here, my lords, one difference perhaps could be that in a similarly worded provision for appeal, the Honorable Supreme Court says delay can be condoned. A parimateria provision.
Which is that ruling?
That ruling.
Parimateria ಅನ್ಲಿಕ್ಕೆ ಬರಲ್ಲ ಅದು. ಅದು subject matter of the statute ಮೇಲೆ depend ಆಗ್ತದೆ. To say parimateria,
Please.
which Sutherland considers, to say parimateria, there are parameters.
My lords.
ಬರೀ ಆ section ಆ ರೀತಿ ಓದ್ತದೆ ಅಂದಾಕ್ಷಣ parimateria ಆಗಲ್ಲ.
I bow down, my lords, to what falls from your lordship. I am submitting, my lord, that under the same statute, appeal provision, the Honorable Supreme Court says delay can be condoned.
In this statute.
In this statute, but for the appellate tribunal. I am saying, my lords, by analogy therefore.
But applies to appellate tribunal, applies to DRT also.
Please, my lords, because the statutory language is similar.
Subject matter is same.
Subject matter is the same.
Is it true?
No, sir.
No.
Mardia
ನಿಮ್
chemicals.
ರೂಲಿಂಗ್ ಕೊಡಿ.
Please, my lords.
Mardia ಆದ್ಮೇಲೆ ಅಮೆಂಡ್ಮೆಂಟ್ ಆಗಿದೆ.
ಅಲ್ಲ ಅದಾದ ಟ್ರಾನ್ಸ್ಫರ್ ಅಲ್ಲಿ ರೆಫರ್ ಮಾಡಿದ್ರೆ ಇಟ್ಸ್ ಅಪ್ಲಿಕೇಶನ್ ಫೈಲ್ಡ್ ಅಂಡರ್ ಸೆಕ್ಷನ್ ಇಸ್ ನಥಿಂಗ್ ಬಟ್ ಒರಿಜಿನಲ್ ಸೂಟ್ ಟೈಪ್. ಸೊ ಸೆಕ್ಷನ್ 70 ದ ಲಿಮಿಟೇಷನ್ ಆಕ್ಟ್ ಇಸ್ ನಾಟ್ ಅಪ್ಲಿಕೇಬಲ್. ದಟ್ ಇಸ್ ದ ಒಬ್ಸರ್ವೇಷನ್.
ಅಪೀಲಿಗೆ ಬರುತ್ತೆ.
ಅಪೀಲ್ಗೆ ಸೆಕ್ಷನ್ 18 ಗೆ ಬರುತ್ತೆ.
5 ಆದಂಗ ಆಗ್ಬಿಡ್ತದೆ.
ಇದಕ್ಕೆ 17 ಗೆ ಬರಲ್ಲ.
In a list of authorities that is already filed, my lords.
ಇಟ್ಸ್ ಅವೈಲೇಬಲ್ ಇನ್ ಕೋರ್ಟ್ ರೆಕಾರ್ಡ್.
ನೀವು DRT ಗೆ ಹಾಕೋದು ಒರಿಜಿನಲ್ ಪ್ರೊಸೀಡಿಂಗ್ ಆಗತ್ತನು?
ಹೌದು 17 ಅಲ್ಲಿ ಒರಿಜಿನಲ್ ಪ್ರೊಸೀಡಿಂಗ್.
ಒರಿಜಿನಲ್ ಪ್ರೊಸೀಡಿಂಗ್ ಆಗುತ್ತೆ.
Please, my lords.
But courts have always maintained difference in England and in India.
Original as well as appellate proceedings.
Original jurisdiction, appellate jurisdiction.
Right.
ಯಾಕಂದ್ರೆ appellate jurisdictional continuation of the original ಅಂತ ಆಗತ್ತೆ. ಇದರಲ್ಲಿ ಒರಿಜಿನಲ್ ಅಲ್ಲಿ ಇನಿಷಿಯೇಷನ್ ಆಫ್ ದಿ ಒರಿಜಿನಲ್ ಆಗ್ತದೆ. ಹಾಗಾಗಿ for filing suit,
Please.
original jurisdiction.
Please, my lords.
That may be one of the point, whether that is discussed that way, how that, let us see the judgment.
Please, my lords. It's file agit.
Page number.
In the judgments, I have already filed, my lords. It's at serial number 8, page number 8.
So your analogy,
Please,
your analogy argument will have no place because the appeal stands on a different footing.
my lords.
In all civilized jurisdictions, for appeals, ordinarily delay is condoned.
My lords.
But for original proceedings, except where like Cooperative Societies Act, the Waqf Act nalli to file suit, delay can be condoned. There is such a provision
Please.
that, but such provisions are absent in these cases.
To that, my lord, my respectful submission is one answer could be that in most suits, there is a reasonable period provided. Here the period is 45 days. This is a statutory remedy. This is a statutory action for which a statutory remedy is created.
Correct.
And therefore, my lords, 45 days being too short a time period.
Mean to say 500 MPs of the country don't understand what is reasonable, what is not reasonable. In their wisdom,
Please, my
with
lords.
the parliament does these things with accumulated wisdom.
Please, my lords.
It will have a lot of wisdom that enters lawmaking. If you see C.K. Allen's Law in the Making,
Please.
how laws are made, lot of experience. Therefore, Oliver Wendell Holmes said, the life of law is not logic,
But experience.
it is experience gained through the centuries. That way it is done.
There, my lords, my respectful submission is that both the language of the statute and, my lords, this legislative device of using words such as but not thereafter was available to the parliament. For instance, my lords, it is used in the Arbitration Act. It's used in other similar commercial legislations such as, my lords, the Companies Act, the Bankruptcy Code. Even in Surface Act itself, elsewhere, the parliament uses that language to say this shall and but not thereafter. But in this provision, that language, that statutory device which they have is found missing.
Which is that section,
Please, my lords.
right to appeal,
Will your
Any
right to appeal,
person-
my lords, is section 18.
17,
17 is the DRT.
Section 17, my lords, is the original application.
which you made to DRT.
Please, my
Yes.
lords.
So there itself delay is not condoned.
There itself delay is not.
So let us see that section.
Please, my lords. Section 17(1) itself.
Any person in that, the judgment itself, it is called out, na?
Yes.
Page 19, Andhra Pradesh judgment.
Yes.
How various high courts in the country have viewed this,
Not except one high court, every other high court has held in my favor.
which is that high court?
Cochin, my lord, says delay cannot be condoned.
Kolkata also.
Calcutta also.
I also quoted it. Detail, there's a Mardia chemical transfer all referred in that judgment also.
Which is the first judgment which treated on delay.
Supreme Court judgment on the.
This Baleshwar Dayal, my lords, is the original judgment at serial number 8.
Page number?
Page number 8, my lords. This judgment of the Honorable Supreme Court refers to judgments at serial number 3 and 4, which are judgments of, my lords, the Gujarat High Court and the Andhra Pradesh High Court.
This was 9/18.
On
not,
18.
17.
Not on 17.
Let us see the reasoning.
Please. Lord, may kindly see page 11, para 1, the question is precisely this. Question in this batch of appeals is whether the appellate tribunal under the Act has the power to condone delay in filing an appeal under 18(1) of the Act.
Where it is?
My lords, page number 11,
You are right.
please. Leave granted, the question in this batch of appeals is whether the appellate tribunal under the Securitization Act has the power to condone delay in filing an appeal under section 18(1) of the said Act.
They referred to 17 also anywhere?
17,
I,
there is no
first
reference.
judgment I cited, my lord, in this one.
There's no reference to 17 here.
Sorry for interruption, madam.
Yes.
In fact, prayer respectively, see, his prayer is only to set aside the order of DRAT Chennai, not
Correct.
the order of DRT Bangalore.
No, not necessary. That merges into that Chennai order. We have held that way. Yes.
But the reasoning starts at para 5.
Para 5.
Para 5 at page 12.
No, as he rightly points out now,
Please.
there is always a jurisprudential difference maintained between condonation of delay in the original proceeding
And at the appellate stage.
and even in original proceeding, there is a provision for condonation of delay.
No,
My lords.
No,
no.
In, in this act, neither in the original proceeding, nor in the appellate proceeding, there is a specific provision for condonation of delay. In this judgment, the Honorable Supreme Court reads in that provision by referring to the provisions of the RDB Act, because the procedure for the tribunal under the Surface Act in turn refers to the RDB Act. Therefore, my lord, the Honorable Supreme Court says, by analogy, that provision will apply, delay can be condoned.
On
Which is the earliest judgment which decided whether delay can be condoned or not under 17?
Under section 17.
Which is the earliest judgment? You said conflicting judgments of
Please, Manoj.
various high courts, Kerala and Calcutta said against you and other high courts said.
Please.
Just tell us the date, which is
Please.
the earliest judgment.
Please.
This we are asking because
Please.
of Kusum Got.
I follow.
Kusum Got said, if
Please.
a central legislation is interpreted, that is how we have interpreted Kusum Got at least.
Yes.
If central legislation is interpreted by one of the high courts, ordinarily other high courts are bound by it.
Please.
The division bench said like that.
Please.
So if that is so, that goes against you or in your favor?
my lord, one Supreme Court's judgment I cited, that's also record,
On 17 only,
17 only.
which is that?
As a page number 90 of my compilation, big paper book is it.
Covered, answered the issue.
Concept section 17 Melbourne.
Kodi. Then where is the question of much argument?
Right.
Kodi.
If
Last
Let us
judgment.
see. ಇದು ಇವ್ರು ಹೇಳೋ ಜಡ್ಜ್ಮೆಂಟ್ ಆದ್ಮೇಲೆ ಬಂದಿದ್ಯಾ?
22.
22. ನೀವು ಹೇಳೋ ಜಡ್ಜ್ಮೆಂಟ್ ಯಾವ್ದು ಮನು?
this is 2016, Manoj, Baleshwar Dayal.
ಈ ತರ ಇದೆ.
Baleshwar Dayal is referred to in that judgment?
No, my lord.
Not referred, because it did not refer to 17 at all. It was Baleshwar is concerned 18.
That's a securitization and reconstruction of financial assets of enforcement of Security Interest Act 22. Section 17, the reason for providing the time limit of 45 days for filing the application under section 17 can be easily be inferred from the purpose and object of the enactment. Surface Act is enacted for quick enforcement of the security. That is the
So no delay can be condoned ಅಂತ ಎಲ್ಲಿದೆ? ಓದಿ ಆ sentence.
ಅದರಲ್ಲಿ reason for providing the time limit 45 days for filing the application under section can easily be inferred from the purpose and object of the enactment. In Transcor versus Union of India, this court held that surface is enacted for quick enforcement of the security. It is unfortunate that proceedings were probably that has been brought to sale and third-party rights created under the provisions of the act have remained inconclusive even after a decade. That's why here also
No, that was the limitation for disposal of the proceeding.
there is
Where is the limitation for approaching the tribunal? 17, DRT.
yeah 45 days. There's a starting point. is-
Where they said that beyond 45 days, nothing can be done. Matter ends there.
that observation only, it's in enforcement is within 45 days we have to approach. Otherwise, purpose.
ಅದೆಲ್ಲಿದೆ ಹಂಗ ಆದಿತ್ಯ ನೀವು ಹೇಳೋದಿದೆಯಲ್ಲ ಅದೆಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ ಒಂದ್ ಸೆಂಟೆನ್ಸ್ ಅಪ್.
7th paragraph. After hearing the company, its directors and legal representatives of the deceased directors, the DRT dismissed the section 17 application on the ground that it is filed beyond the statutory period of limitation 45 days. According to section 17 subclass 1, the period of limitation is 45 days is mandated to commence from the date on which the measure under the section 13 subclass 4 has been adopted, which in fact and of the present case is the date when the secured asset is sold in favor of respondent number 7. The above referred order was challenged in review. DRT by its order dated 8/8/2016 allowed the review on the ground that Rakesh Sharma had expired before the auction had taken place and that his legal representatives were not issued notice. It is rather strange that the DRT not only entertained the review petition but has allowed the same on the aforesaid ground. The order in review was challenged before DRT, which found no difficulty in allowing the appeal on the ground that there was never been an error apparent on the face of the record for exercising the review jurisdiction. It is this order of DRT that was challenged before the High Court in the writ petition filed by the company, its directors and also the legal representatives of the deceased director. This very same ground was raised that one of the director had expired and his legal representative were given notice, were not given notice before the secured asset was brought.
ಬ್ರದರ್
Huh?
ನಾವು ಪ್ರಪೋಸಿಷನ್ ಮೇಲೆ ಇದ್ದೇವೆ. ಹೋಲ್ ಜಡ್ಜ್ಮೆಂಟ್ ನಾವು ನೀವು ಓದ್ಕೋತ ಕೂತ್ಕೊಂಡ್ರೆ ಉಳಿದವ್ರು ಏನ್ ಮಾಡಿ ಲಾಯರ್ಸ್ ಇಲ್ಲಿ
ಅಲ್ಲಲ್ಲ, ಅದರ
we are asking which is the paragraph. Therefore Supreme Court said when you are citing decisions, you should point out the paragraph.
Aril, we are only concerned with the limited question as to whether the High Court was justified passing the interim order on as extracted here in the above. This is the case.
Limited question.
This is a case where the company with its own independent identity is contesting the proceedings. It is apparent that the directors were also contesting the matter by filing the Section 17 application. Even the legal representative of one of the deceased directors were party to the application under Section 17. Further, DRAT came to the conclusion that the original order passed by the DRT has been arrived at after detailed consideration and there no justifiable ground for invoking the review order. The reason for providing the time limit 45 days in filing an application under Section 17 can easily be inferred. So this court held that the SARFAESI Act is enacted to quick enforceability of the security. It is unfortunate that the proceedings were probably, that's all I read. Though the special leave petition was pending in this court since the last 5 years, this court at the stage of admission had granted a stay for an impugned order. The consequence of which would be that High Court's interim order has not come into operation. The effect of the interim order passed by this court is that order of DRAT upholding the dismissal of the application under section dated would continue to operate. For the reasons stated above, we are of the opinion that High Court was not justified in staying the operation of the order of the DRAT, which came to the conclusion that there was no error apparent on the part of the face of the record of the DRT in invoked review jurisdiction and recall the order dismissing the application under Section 17. There is my lord, the observation
Judgment kodi.
available in the court file. ಈ ತರದ್ದು ದೊಡ್ಡದು ಹಾಕಿದ್ದೀನಿ, ಫುಲ್ ಹಾಕಿ, 2 ಸೆಟ್ ಹಾಕಿ.
ನಿಮ್ಮಲ್ಲಿ ಇನ್ನೊಂದು ಕಾಪಿ ಇದೆಯೇನು?
ಕೊಟ್ಟಿದ್ದೀನಿ.
ಅಲ್ಲಿ ಮ್ಯಾಂಡೇಟರಿ ಸೆಕ್ಷನ್ 17 ಈಸ್ ಲಿಮಿಟೇಷನ್
Listen, ನೋಡಿ.
ಪ್ರಿಸ್ಕ್ರೈಬ್ಡ್ ಅಂಡರ್ 17 ಈಸ್ ಮ್ಯಾಂಡೇಟರಿ ಅನ್ನೋ ಸೆಂಟೆನ್ಸ್ ಓದಿದ್ರು ಅವರು.
Please.
ಪೇಜ್ ನಂಬರ್
28, the page number
28.
Judgment begins at
90,
page 90.
90,
90.
last judgment.
Para 12, 13, 14. Mr. Manu,
Lord.
they go against you.
My respect.
Though not very articulatedly, there is scope for improvement even in heaven, said Oscar Wilde, may be applicable to every judgment. But section 17 court said the text of section 17 about prescribing limitation is mandated.
Quinn versus Leatham.
The one judgment which you are now referring is under 18.
Please.
Therefore, as between two judgments, the Constitution bench said, the facts which are nearer to the facts of the case at hand should be adopted.
Quinn versus Leatham.
Quinn versus Leatham.
Para 11 per sentence.
Read.
We
Lord
are-
Halsbury's judgment.
Lords. So that ratio, relying on that ratio, para 11, we are only concerned with the limited question as to whether the High Court was justified in passing interim order as extracted herein above. That was the only question before the Honorable Supreme Court. Para 15, your Lordship may see.
It interpreted.
Please.
Quinn versus Leatham is 1901 judgment of the House of Lords.
Please.
It laid down certain principles as to the law of precedent is true.
Lords.
But question is, if the apex court, see this, the Kodamai, when law is declared under 141,
My lords.
the apex court said, the three-judge bench apex court said, headed by Justice Babu, when law is declared under 141, it is not merely on the doctrine of precedent. It is on something else ಅಂತ hold ಮಾಡಿದ. Barkatullah versus Rudramurti. They say it is not just on the doctrine of precedent. It is something more.
Lord, in fact, in a recent judgment, my lords, of Lordship Justice Narasimha, Lord, a distinction is made between what is called as the precedent setting function of the Honorable Supreme Court and the decision making function.
I think it is two judgment decision which you are referring
Please,
to.
please, my lords, 2025.
Judgment. The latest judgment.
Please, please, my lords.
Whether Justice Arvind Kumar was also on the bench? No. Just B.H. Narasimha's judgment.
Please.
ಅಲ್ಲಿ ಬರ್ಕತ್ತುಲ್ಲಾ ವರ್ಸಸ್ ರುದ್ರಮೂರ್ತಿ ಅಥವಾ ರುದ್ರಮೂರ್ತಿ ವರ್ಸಸ್ ಬರ್ಕತ್ತುಲ್ಲಾ. Take out that judgment. Read para 6 of that judgment.
Please.
Take out from your
Please, please.
literature. Correct. Rudramurti versus Barkatullah. It arose from Karnataka under the Rent Control Act. Just read para 6.
Please.
Justice by Rajendra Babu, Honorable Justice Rajendra Babu.
Indian Canon is open.
Para 6 or 7, I correctly, I don't know, perhaps 6 it is, I remember. Correct. Bhatia case was considered. While in that, read just para 6, Aditya. Correct. That was Justice Ramajoy's judgment. Yes.
Indeed, it is a matter of doing discipline that requires a solution matter. And the court telling us as to what the law of the matter is. The state should be finding out what's within the regulation. The mandate of Article 141.
Slowly read that sentence.
The mandate of Article 141 of the Constitution is not
Imprimatur.
Yes. It is not based on the doctrine of precedent. The first of its kind it is. So law is declared, I think it partakes the character of law to be made by the conventional legislature. That way it will be. Therefore, you need not find so much jurisprudential material when the law is stated by the Supreme Court. We need not go to Rupert Cross at all to find out that
Wombox test.
Wombox test, Upendra Bakshi's test. These things we need not. If the law is declared, as we understand from the judgment, we need not much travel to the doctrine of precedent at all, except in the cases where Justice P.S. Narasimha said last 2 weeks ago, perhaps,
Please.
in that one. Except in that case.
Please.
Therefore, we don't think that you have any case in this.
Lord, in this judgment, my respectful submission is.
Yes.
There is that sentence, my lords, that delay cannot be condoned under any circumstances is neither expressly found
No, this
nor
is mandatory.
Mandatory word.
The word mandate is
Please.
there. Kindly come to see, you should also read one best article by Dr. Upendra Bakshi, How Not to Read a Judgment. There is an article. Really, it's a very good article.
yes.
This is for those who are academically interested.
Please.
For those who need not read, they need not get annoyed by my words at all. See that, para 6, you just see.
Please, notes. The present proceedings commence with a challenge to the above referred sale certificate in an application under 17 of the Act by the respondent company and its directors. It is important to mention at this stage that the application under 17 was filed by the company, its 3 directors, being Shri so and so. The other director, Shri Rakesh Sharma, who expired on so and so, was represented by his legal representatives.
Come to 7 now.
Please. After hearing the company, its directors and the legal representatives of the deceased director, the DRT dismissed the section 17 application on the ground that it was filed beyond the statutory period of 45 days.
45 days.
According to 17.1, the period of 45 days is mandated to commence from the date on which a measure under 13.4 has been adopted, which in the facts of the present case is the date when the secured asset is sold.
So, number 1.
Please.
Then it dismissed the challenge. The challenge was on that ground.
Please.
17 is not mandatory. It is more directory that way.
Right.
That's how the judgment has been structured. There
Yes.
is scope for improvement even in heaven is another thing.
Right.
But from this reading of this judgment, we feel that
Right.
law is declared by and the one which you are citing is under 18. We are repeating.
Please note, it's under 18.
18.
My respect.
If 141 were to be founded solely on the doctrine of precedent,
Right.
perhaps the 3 conventional tests whereby we take out the ratio decidendi, there would have been scope for invocation, but not in this. Because of Justice Babu's judgment. 141 is not founded on doctrine of precedent. This is what 3 judge bench said.
Please. Note.
I think three judge bench, Aditya, 3 judge bench decision. I believe that way.
It is
Because Ratanaria, Bhatia,
Justice Punchi, Justice Patnaik, and Justice Babu.
correct. Honorable Chief Justice Babu wrote that judgment.
Please. Note. My respectful submission is, in para 11, the Honorable Supreme Court says what is the only question the court is dealing with.
Correct.
Therefore, 141 has to be restricted to the question that the Supreme Court itself identifies. In para 11, one sentence. We are concerned with the limited question as to whether the High Court was justified in passing the interim order as extracted herein above.
That was founded,
Please.
on the interpretation of 17.
Notes. Now your lordship may please see what the Honorable Supreme Court does in para 15. The matter is not disposed of. In conclusion, we allow the appeal.
Mr. Manu, we are concerned with what the Supreme Court says
And not what
and
it
not
did.
with what it does.
Please.
It may say something, may do the exactly reverse. What it says is our concern because law declared what the Supreme Court does, it does so many things. We are not, it's not our concern. What Supreme Court says is the law.
Not. In fact, in the 9-judge bench decision in the property association matter, Lord, which is larger than the 3-judge bench, the Honorable Supreme Court applies the principles of how one is to deduce the ratio. And my lords, there is ample reference to 141 in that judgment also. But may I, my lords? Property Owners Association. Lord, if your lordship gives me a moment, my lords, I will trace it.
Just runs counter to para 6 of Barkatullah.
Lord, I am not certain, my lords. I don't think there is a reference to that decision. But my lords,
No, in variance with it, there may not be
yes,
reference.
it would be, my lords, in variance. I will just.
But in my limited reading, that is the only decision which said 141 is not founded on doctrine of precedent.
Candidly, my lords, I had also not, until your lordship pointed it out, my lords. 2022, correct. INSC 835.
One more point, my lord, section 29 limitation at exemptions under this under tribunals also. This is not applicable because it's special.
29 says
Supreme.
where special law is there.
Yeah, this is special. law.
That's why. Therefore, it will not travel to 29 at all.
No.
Because limitation act applies only to the courts.
Courts. This is
not a
tribunal.
court.
This is
a
tribunal.
tribunal.
Yeah.
Therefore, you need not invoke 29 at all.
And what my submission is for condonation of section 5, not applicable for the tribunal.
Because it is a tribunal.
Tribunal,
Act itself is not applicable.
not applicable. That is the one of the Supreme Court also in another testament.
Yes, there when we were in second year law, our professor used to say 36 years ago. Yes. ಏನಿಲ್ಲ ಮನು ಮಹರ್ಷಿ.
Lord, in property owners, 9 judge bench, Lord, some sentences, if I may read just from the head note. The single sentence observation in Mafatlal case to the effect that material resources of the community include privately owned resources is not part of the ratio decidendi of the judgment. Therefore, the Honorable Supreme Court, my lords, goes on to, this is one of the findings.
That's true because
Please.
in Mafatlal, 1997, 98 Supreme Court,
Please.
97 or 98 Supreme Court, the question was different.
My lords,
There is one single sentence. Therefore, the comment made that. It is not that section 141 will keep doctrine of precedent miles away,
please, my lords.
but it is not founded on doctrine of precedent. That is how Mafatla 97, Nariman's argument.
Please.
That's true.
My lords, para 111 in the neutral citation.
We don't have a quarrel with that proposition. It only reminds me of what Shakespeare said, one swallow makes not the summer. That way it is. But law is declared here.
Lord, my respectful, I will just read one paragraph, my lords, from the 9 judge bench.
Read.
Not every observation in a judgment of this court is binding as precedent.
Correct.
Only the ratio decidendi or the propositions of law that were necessary, and my lords, necessary is in bold here, that were necessary to decide on the issues between the parties are binding.
Correct.
Observations by the judge, even determinative statements of law,
May not be.
which
binding.
are not part of the reasoning on a question or issue before the court are termed arbiter. Such observations do not bind the court.
Correct.
More simply, a case is only an authority for what it actually decides.
Decides.
Quinn versus
Twin
Lidham.
versus Lidham. Correct.
But in that light, my lords, my respectful submission is in para 6 and 7, what is seen as mandatory is the starting date of limitation, not the end date. Here the question was, my lords, in the facts of this case,
The court was considering not starting date at all.
my lords,
17.
17 indeed,
Whether the period prescribed under 17, 45 days,
please, is mandatory or not.
mandatory or
Lords,
there is sufficient indication.
In-
In little English, we may not be good in English. After all, English is a foreign tongue. But we understand this judgment that
para
we may be wrong also.
But para 12, if your lordship sees, my lords, at page 92,
Para 12 of,
para 12 at page 92 of the same judgment that my learned friend has relied on.
yes,
The reason for providing a time limit of 45 days for filing an application under 17 can easily be inferred from the purpose and object of the enactment. In transcore, this court held that SURFACE Act is enacted for quick enforcement of the security. It is unfortunate that proceedings where a property that has been brought to sale and third-party rights created under the provisions of the Act have remained inconclusive even after a decade. This is the only observation.
Correct. Because when it said 75,
Please,
45 days
please, my lords.
to start the proceeding,
Please, my lords.
the object, it is indicating within what period you should do everything on war footing.
My lords.
To indicate that it is safe. Anyway, dismissed on the
Lord, on-
ground that
on-
section 17 is mandatory and therefore
Lord, on
the-
facts, I may have one more slight distinction, Lords. On facts, I had filed an amendment application. That amendment application was filed on time. But then I realized amendment application is not the correct remedy. And therefore, thereafter, I filed, my lords, an application, a fresh application. Will your lordship just see those facts?
amendment application.
Please, my lords, I file an amendment application.
When did you file the original application under 17? Give the date.
Please, my lords.
Whether by that time 45 days were over or not. Please be plain to that.
Yes, my lords. That's why I filed a list of dates, my lords.
Then other questions will not.
Page number 254, my lord.
Yes.
Of his paper book.
Now, if you admit,
Please, my
in
lord.
all fairness,
Please, my lord.
that if you have filed the application under 17 after the expiry of 45th day,
Please, my lords.
which you have filed,
I have, my lords.
then you have no other cases.
This
Will
case-
will your lordship just see 3-4 list of dates, my lords?
Yeah.
At page 32, at serial number 32, I file an amendment application first. I file an amendment application to amend the existing application.
That application itself was 5 time barred,
The first application,
first time barred. It was time barred.
not the second application was time barred.
No, no, sir.
No,
Question itself.
even first application was time barred.
Both were time.
Both were.
Both.
Well, the Supreme Court said that that also is considered. I think Justice B.K. Mukherjee of Supreme Court has said, where suit itself is 5 time barred, any application seeking amendment to
That
will
was.
not be maintainable.
There are-
Justice B.K. Mukherjee, one of the great judges of our Supreme Court. The Mukherjee he was referred in Tagore Law lecture by one famous judge of the US Supreme Court. I don't remember his name. From Madison to Mukherjee, something like that. He said, this is the law from Madison to Mukherjee. That stature. He said that.
Last is
Ah.
2 judgments of the Honorable High Court on section 17
Ah.
were referred to by the Honorable Supreme Court in Baleshwar Dayal. Lords, when interpreting section 18,
That is 18. Alonama, difference has to be maintained between the approaches to 17 and 18.
18.
17 is original proceeding and 18 is appellate proceeding. First, for more than a century, it has been the law that appellate proceedings are the continuation of the original proceeding. And that while condoning delay in invoking appellate jurisdiction, ordinarily courts will be with liberal, subject to all just exceptions. First, the decision cited by Manu Kulkarni admittedly relates to section 18. First off, when specifically asked as to whether section 17 is also referred to in the said decision, he in all fairness admits it is not. First off, next paragraph. As between 2 decisions cited at the bar, court has to choose one which nearly matches to the facts of the case being treated at hand. First, this apart, Kerala High Court and Calcutta High Court
There-
have held as we are holding now. First, we don't, we respectfully disagree with the judgments of other,
Baleshwar. and
not Bageshwar.
Gujarat High Court, Andhra Pradesh High Court.
Gujarat High Court and Andhra Pradesh High Court. Okay. Our judgment separate ಮಾಡ್ಕೊಡಿ, our judgment ಅನ್ನ. Next paragraph. We also observe that Article 141 of the Constitution is not essentially founded on the doctrine of precedent, as has been held by the 3 judgment decision in Barkatullah versus Rudramurti, para 6, which reads as in the above circumstances, petition is dismissed.
Great.
Much
ಅದೇ
obliged.
ಈಗ ಇಂಪ್ಲೀಡಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಕನ್ಸಿಡರ್ ಮಾಡೋ ಅಗತ್ಯ ಬೀಳೋದೇ ಅಲ್ಲ, ಸಿನ್ಸ್ ವಿ ಆರ್ ಡೂಯಿಂಗ್ ದಿಸ್. Please. Okay.
Great.
But already we have dictated the order, na? ಅಲ್ಲಿ ಅಮೆಂಡ್ ಮಾಡಿಕೊಡಿ, ಕಾಸ್ಟ್ ರೇಟ್ ಅಲ್ಲಿ ಅಮೆಂಡ್ ಮಾಡಿ.
Amend ಮಾಡಿ.
Okay.
That actual method is from Marshall to.
Marshall to Mukherjee, not Madison. Marshall to Mukherjee. Who is the judge who say? No, no. No. English judge. No, no. American judge said. Who he had come to only deliver a Tagore law lecture. From Marshall to Mukherjee. That famous statement, Mr. Naganand, who said, Marshall to Mukherjee, this is the law. That who came for Tagore lecture years ago.
Setalwad perhaps, not MCC.
Not that. Anyway, that name is on the tip of tongue. Sometimes tongue plays.
William Douglas perhaps?
Douglas. Douglas, correct. No, Douglas, William Douglas. He had come to India. Yes. Because he was astonished after seeing Justice B.K. Mukherjee's library. He was simply astonished. And his wife asked Mukherjee as to whether you have a book on tiger hunting. Then judge asked, is it a male tiger or female tiger? We have both the books. Such a huge library here. Yes.
Great.
Yes. I think our Sudesh Pai has written one book on Justice B.K. Mukherjee himself.
P.B. Mukherjee.
Huh?
Justice P.B. Mukherjee.
P.B. Mukherjee.
P.B. Mukherjee.
Is it, it's not B.K. Mukherjee?
No, no, P.B. Mukherjee. He is the elder brother of Justice Aforesaid Mukherjee.
Okay, okay. Maybe. P.B.
Much
Mukherjee.
obliged.
Yes, very. Okay.
My lord. The petitioners,
Yes.
being a developer of the project around Arovilla. Respondent number 1 and 2 are the home buyers.
Petitioner is developer.
Yes, ma'am.
Ah.
They have developed the project called around Arovilla. Respondent number 1 and 2 are the home buyers. We could not complete the project. They approached the Honorable State Commission, obtained the order for refund of the amount. After that order was passed in the November, December, around Arovilla project went to NCLT in the view of the Kotak Mahindra. NCLT moratorium period was declared. Later, that scheme was approved by the NCLT. These home buyers, despite notice, they have not gone and approached the IPR. Now they have filed a execution petition. In that execution petition also I have stated IPR is pending, go and approach. That is noticed by the State Commission.
Moratorium clause.
Yes, my lord. After moratorium,
Where is that moratorium clause? Which section?
yes, 14, my lords.
14.
Yes, ma'am. 14, I have produced that, reproduced, and it is accepted now. Now scheme is accepted. On Golden Hatcheries has taken over the project. Now they are trying to enforce against me that project is not with me.
What Apex Court said in 2017 Nariman judgment?
In the latest judgment, after amendment to the section 5, home buyers also coming within the purview of the creditors, my lord.
Right.
Yes, ma'am.
So they have to go there only.
Yes, my lord.
Issue emergent notice, interim order as prayed for. First off, this interim order is protection is granted in view of decision of the Apex Court in. So
Vishal Chelani.
Very copy. So to some extent, Nariman's judgment is tweaked by the parliament after amendment.
Yes, yes, madam. In 2018, the amendment was carried out. They brought the home buyers within the purview of the financial creditor, madam. Yes, madam.
Yes.
Supreme Court remand matter, question number 2 and 3, transfer pricing issue, my lord.
Dodama. Question numbers 2 and 3.
Your Lordship, in this case, question number 1, 2, 3 are relating to transfer pricing issue, my lord, relating to 1 to A to E, my lord, transfer pricing issue, my lord, whether the method adopted by the assessee is correct or not, transfer pricing method.
ಅದು ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಗ್ತಾ ಇದೆ ಏನು?
ಅದು ಅದ್ರಲ್ಲಿ ಇಲ್ಲ, but similar matters are pending.
I'll just submit. The question here is whether expenses that I incur on advertising, marketing, promotion is a separate international transaction. Undoubtedly, it's a question of law. In what your lordships are considering, whether transfer pricing cases, questions of law arise and all that after
Avila-
remand by the Supreme Court,
Wait.
that's a different matter. Here, it is a question of law, no doubt. But Delhi High Court in 3 judgments have said that AMP expenses is not a separate international transaction which can be benchmarked by the transfer pricing officer.
That is not challenged.
One of the decisions of the Delhi High Court has been, SLP has been dismissed by the Supreme Court.
After considering or admission still.
Yes, SLP dismissed. It's just a SLP dismissed.
Because
I must point out that the other 2 decisions of the Delhi High Court are pending still before the Supreme Court. 1 out of 3 SLP has been dismissed. I just wanted to point that out.
Your
And the
Lordship,
first 2 questions,
ಅಲ್ಲಿ ಸ್ಟೇ ಇದೆಯೇನು ಡೆಲ್ಲಿ ಹೈಕೋರ್ಟ್
that
ಜಡ್ಜ್ಮೆಂಟ್?
stay in it.
ಸ್ಟೇ ಇಲ್ಲ? Are you sure?
Yes, yes. I'm sure my learned friend can also. There is no stay of the Delhi High Court. One of the 3 judgments, SLP has been dismissed. I'll just pass on the SLP.
ಅಲ್ಲಿ ಏನಾರು ಇದೆಯಾ? ಕ್ವೆಶ್ಚನ್ ವಿಲ್ ಬಿ ಕನ್ಸಿಡರ್ಡ್ ಇನ್ ಅಪ್ರಾಪ್ರಿಯೇಟ್ ಕೇಸ್ ಹಿಂಗೆಲ್ಲ ಅಂತ ಅದು ಲಾಸ್ಟ್ ಟೈಮ್
ಅದು ಇಲ್ಲ, ಅದಿಲ್ಲ.
ಅಂತದ್ದು
ಅದಿದ್ರೇನು I have now found a case law which says that that will only apply to the Supreme Court.
ದಟ್ಸ್
The
ವಾಟ್
High Court judgment is still binding on the court.
ದಟ್ಸ್ ವಾಟ್ ಐ ಫೆಲ್ಟ್ ದಟ್ ವೇ.
Your Lordship, there are also other high court judgments, my lord, which are in favor of the revenue, my lord. And those.
ಯಾವ್ದು ತೋರಿಸಿ?
There is
Your
no,
Lordship,
to my knowledge, there is no contradiction by any other High Court.
ತೋರಿಸಿ ನೀವು ಹಿಂಗಿದ್ರೆ.
Your Lordship, today are not carried, my lord. Because Your Lordship, this issue is already admitted in the assessee's own case for earlier assessment here.
Correct, but
Then-
now because we did not have the advantage of
Yes, my
Sundarana
lord.
here.
Your Lordship, I will just get all the details, my lord, in the next week, my lord.
Next week ಮಾಡಿ. Call next week at the request of learned panel council.
2 weeks. my lord.
ಹಂಗಿದ್ದಾಗ ತೊಗೊಂಬರ್ಬೇಕು ನೀವು.
ಇಲ್ಲ, because all the
Otherwise
four-
ಇಂಥವೆಲ್ಲ ಇಟ್ಕೊಂಡ್
Your
ಕೊಡ್ಬೇಕು.
Lordship, 4 matters are already admitted in assessee's case, my lord. Therefore, I thought that. this
ಅವನು
will-
ಅವನು
That was before notice. That was before notice.
ಕೊಡಿ ಯಾವ ನಂಬರ್ ಕೊಡಿ ಅವನು ಮುಗಿಸ್ಕೊಡಿ ಆ ನಂಬರ್ಸ್ ಕೊಡಿ
Those connected matters, appeals, I'll give the appeal number.
ಅಪೀಲ್ ನಂಬರ್ ಕೊಡಿ ಕಾಲ್ ದಿಸ್
Those
ಮ್ಯಾಟರ್
connected.
along with these matters next week.
Please.
ಕ್ವಶನ್ ಫೈನಲೈಸ್ ಆದ್ಮೇಲೆ ನಾವು ಮತ್ ಅದನ್ನ ಹಂಗೆ ಟ್ರಬಲ್ ಮಾಡಿಕೊತ್ ಕೊಡಬಾರ್ದು ಅಸೆಸಿಗಳಿಗೆ. ಅವ್ರು ಕೊಡದೆ ಟ್ಯಾಕ್ಸ್ ಕೊಡೋರೆ ಕಡಿಮೆ 3% ಇದ್ದಾರೆ ದೇಶದಲ್ಲಿ.
Yes.
ಇನ್ನೋದೆಲ್ಲ ಊಟ ಮಾಡೋರು.
Because we have already given the refund in all these cases, my lord.
We'll see that. Yes. ಬೇಡ ಬೇಡ ಮಾಡೋದು. Yes.
Your Lordship, the council is having some inconvenience today, my lord, next week, my lord.
2 weeks at the request of.
Appearing for the appellants in this matter, my lords,
Yes.
I kindly pray for a week's time, my lords. We had to seek some instructions from the department.
All right, 2 weeks at the request of. ಅದ್ರಾಗೆ ನೋಟಿಸು ಆಗಿಲ್ಲ ಅನ್ನೋದು. ನೋಟಿಸ್ ಮಾಡಿ ಎಮರ್ಜೆಂಟ್ ನೋಟಿಸ್ ಏನಿಲ್ಲ.
23 and 24.
ಟೇಕ್ ಎಮರ್ಜೆಂಟ್ ನೋಟಿಸ್ ಆಗಿದೆ, ಅವ್ರು ಬಂದಿಲ್ಲ. ಸ್ವಲ್ಪ ನಿಮ್ಮ ಅಗೇನೆಸ್ಟ್ ಇದ್ದಂತ ಯಾವ್ದೋ ಒಂದು ಜಡ್ಜ್ಮೆಂಟ್ ಓದ್ದೆ.
There is nothing in this.
ಏನಿಲ್ಲ.
Tribunal has remanded it to consider VAT 140 that has been given by the franchises. if my contention here is accepted, there would be a tax on movement of goods rather than on sale of goods.
Tax is on the event of sale, not on movement.
I could have done, the quality of my investigation could have been better, where I could have established that I could have taken the inventory from the consignees and says, allu illa, illu illa, in fact, there is de facto sale and they're attributed. My investigation only comes to the conclusion
That there is movement of goods.
I should have gone a step further and said, movement agide. sale
Therefore,
agide.
it may lead to sale. Without sale, movement would not have happened. That way also it is not built up.
Correct. Clearly there, show me the good. If it is not sold, show me where it is. And show me record of the inventory. Show it to me physically as well as record of the inventory. If I had done that, then the e-Sukha.
But in one judgment I have held, right to move includes right to move with the goods,
Transfer score.
which is that judgment.
Transfer score.
We said,
Yes.
because we referred to some American justice, Neely of American State Supreme Court.
I had appeared in.
And we referred to Sartha by Bhairappa. Just take out that judgment.
I'll take it out.
Because Constitution does not say right to move, means you should move barehanded.
Your Lordship, so sitting with Honorable Justice Huda,
Correct.
writ appeal 854 of 2022.
Madam, or barli, or pass over my, just,
Joint Commissioner versus Transways India for Transport.
yes. Dismissed, madam. Perfect. Dismissed. Dismissed. In view of the fact that what has been demonstrated is the movement of goods and not the event of sale, which is the taxable event.
With regard to interstate sales,
Ah.
there is the definition of turnover it comes, but the finding by the Additional Commissioner on Facts is that these are intrastate, so I can't even take benefit of the.
There is no scope for invoking the idea of interstate sale. Still, either there being a specific finding as to intrastate sale. First, whether
Interstate
sale is
consignment.
intrastate consignment, whether it is an intrastate transaction or interstate transaction falls within the realm of question of fact. And therefore, it is not revisable. First, dismissed. Alone, that's not judgment on Kodavik. Refer to so and so. Okay. So 23, 24, both will go.
My lord.
Lordships, may I make a mention?
Yes.
Apologies, there is a terrible fluctuation of network today, Your Honor. Serial number 9 and 12. If Your Honors, we are outstation, if specific date of next week, Thursday could be given, we'd be very grateful, Your Honors.
9 and 10.
9 and 12, Your Honors.
9 and 12. But we have already written the order 2 weeks.
Adjourned for 2 weeks, Your Honors?
Yes, yes.
If we are outstation, Your Honors, if a specific date could be given of 2 weeks, we'd be very grateful, Your Honors.
You're from outside.
Yes, Your Honors.
But ಬರದಾಗಿದ್ದೇನೆ ಈಗ?
Lordship, transfer pricing issues, my lord.
ಹೌದಾ? But we have already written the order. If there, next time we can move a memo so that we will take that.
Lordship, thank you.
Anyhow, transfer pricing issues are involved there in
Ah.
those 2 cases, my lord. Let it
Anyway,
come.
we have passed the order, na? Okay.
My lord, section
20.
41(1) lays down, my lord, if any expenditure or deduction is claimed in a previous year, and my lord, subsequent year, my lord, they get a remission and get a benefit out of it, my lord, that has to be offered for tax. Here, my lord, the respondent has got a waiver of 119 crores of loan. So if that contains a part of interest which has already been claimed as a deduction, my lord, that should be offered to tax. That exercise was not made by the tribunal. Tribunal, my lords, has held it's always, the total amount is towards the capital. So there is only one question of law raised, my lord, in page number 6.
Requires consideration, brother. Yes. Admitted on which question?
Page, only one question, my lord, page number 6.
Admitted on the following substantial question of law. You appear for respondent. We'll revert within a few minutes. Okay. Let them give the work. You should call and follow up. Somewhere in foreignly. Call for it. To keep a right of passing officer on the passing officer of the file so that you know next. Inquiry.
My lords, they have filed a memo, my lords, to say this matter is below a monetary limit. Because they have given the calculation also, my lords. I've got instruction, my lords, to say this matter, my lords, is above monetary limit. I will file my objections below, irrespective of whatever it is, my lords.
2 weeks at the request. Next.
Transfer pricing as well as the other non-corporate issues are involved. Question 1 to 7, yeah. TP as well as non-TP.
1 to 7.
1 to 7.
Nodama. 1 to 7. Vale, noted.
Your Lordship, other two connected matters, 623 of 23, 632 of 23 are have to be clubbed, my lord.
Call along with 623,
And 632, my lord.
632 of 23. Both are 23.
Yes, my lord.
Call along with. Yes.
This matter can be taken up with 33. My lord said. heard
Along
in
with
part
33.
Same as.
Same assessee, same issue, different years.
Okay. Not ready? Ready.
33
Start.
Mr. Suryanarayan,
Ah.
otherwise I'll do my reply.
Allah, Barli, Suryanarayan, he was here, na? Suryanarayan was
Just
here.
stepped out. no.
Let us.
33 kardaga we'll.
Ah. 29 pass over.
My lord, this appeal pertains to the service tax period, my lord. My lord, this matter, the question is whether the assessee has complied with rule 631 of Senvad Credit Rule 2004, my lord, where the assessee was manufacturing a byproduct of capsicum, that is paprika, and this thing, the seeds they were taking out, my lord. It is deductible and exempted, my lord. They have to maintain two separate accounts for deductible and exempted. Here the assessee has not maintained. In the audit, while we were conducting the audit, we found out that he was not maintaining two accounts. He had availed input tax credit, a common single. So we issued show cause notice. Subsequently, we passed order that because you have not maintained separate two accounts, you are liable to pay 5% to 10% duty on those where you have not maintained the separate accounts, my lord. The
Otherwise, no duty at all.
otherwise, no. My lord, the Honorable Sestak in the appeal proceeded to hold that there was an amendment brought into section 73, wherein retrospective amendment for the period 2004 to 2008, where you can reverse the input tax credit, pay the interest, my lord. Now, in this matter, my lord, the Sestat has followed one judgment of Parley Private Limited. Our main contention is that Parley judgment was suitably for that amendment, that is from 2004 to 2008. Here the period is from 2007 to 2011.
Not covered by retrospective.
Yes, my lord. 8, the amendment stops.
8 is the back period.
Back period. 2004, the benefit was given from 2004 to 2008.
Only that particular
period.
But this is 2000?
This is 2007 to 2011, my.
But 7 will be included.
7 will be included. But for remaining years, it's not included. All I am asking is, my lord, let the matter be remanded to the adjudicating authority. There are various other.
Take emergent notice.
Please, my lord.
At least 7, 8, you can't do anything.
I cannot do it. Because law has
With
retrospectively
retrospective.
The issue of transfer pricing allows comparables. Government bench is coordinating.
Ordinarily, I would not oppose this. Only no allegation of perversity. It's a finding of fact. Can be admitted, maybe.
Well, admitted on the substantial questions of law. Noted. All right.
My lords, in 32, I am told the government has issued a notification amending this land grabbing act. 25 kilometers from the city corporation idre barala jurisdiction anta. 2022 is the
Nothing by
notification
reply
and
on
they have
this.
closed all the cases.
That contention has not been taken before the special court.
No, there is
Sir,
jurisdiction,
contention, a question of law.
question of
But
law.
now that there is judgment has been passed in the special court, my lordship.
Saying,
Saying that what the suit has been filed by the the petitioner, it has been dismissed before the special court. Now the final judgment has been passed, my lordship.
Adinna
final
ತಪ್ಪಾಗುತ್ತೆ.
judgment is in
That has
your
been-
favor.
ಇಲ್ಲ,
That has been-
ಅದಲ್ಲ.
It has been
ಇಲ್ಲ.
dismissed. Dismissed,
Complaint is dismissed.
please.
Complaint was by whom?
Complaint, my lordship.
The jurisdiction ಇಲ್ಲ ಅಂತ.
Complaint is by whom?
A busybody.
lordship.
My lords, what has happened in the matter
Allah,
is,
now it has become infectious only.
He has filed for permanent injunction before the civil court.
Correct.
Then after the act is came into existence,
Transferred.
they has been transferred. Now, based on all the deposition exhibits and all the cross examination by the other complainants, now the special court has.
the
passed
cross
an-
examination ಯಾವುದು ಆಗಿಲ್ಲ.
He has,
The government has not produced any records in the matter.
that's what I'm filing my reply on this, my lordship, because
ಅವ್ರಿಗೆ ಕಾಪಿ ಕೊಟ್ರೇನು?
I'll serve it on it.
ಅವ್ರಿಗೆ ಒಂದು ಕಾಪಿ ಕೊಡಿ.
And regarding this,
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಮಾಡಿ ಏನೋ ಅಬ್ಜೆಕ್ಷನ್ ಆಗ್ತಾ ಇದ್ದಾರೆ ನೋಡಿ.
that's one more issue. If suit for permanent injunction filed by me, can it
Ah.
be transferred to the land grabbing court? That is an issue, my lords. That is not decided till now. Whether
That has been decided, that is what judgment, that has been challenged
no.
before this
Not
court,
by
my
the High
lordship.
Court. This court
Two
has
prior-
not. This court has to decide. Non-suitorly land grabbing, there is no issue regarding land grabbing. There is no counterclaim by the government. Automatically it is transferred. I have taken up the contention before the tribunal and special court and this court also. Same contention. My lords, what has happened is, this is not an ordinary school, my lords. An Englishman constructed the school long back. 1950, the Panchayat told that to certify that one, they granted the land in favor of this Ganpati High School. It's a grantee aid school from 1950. Maharajar Kotirado. They are treating this school very shabbily. Lakhs together students have studied
My
in this
lordship,
school.
Kata
Yeah.
which has been
ನೆಕ್ಸ್ಟ್
issued,
ವೀಕ್ ಮಾಡ್ಕೊಡಿ.
Kata which
ಕೊಡಿ,
has been
copy
issued,
ಕೊಡಿ.
please, my lordship.
There
ನೆಕ್ಸ್ಟ್
are
ವೀಕ್
judgments of the Supreme Court on both the matters, my lords. I'll argue the matter.
ನೆಕ್ಸ್ಟ್ ವೀಕಾ?
Please, my lords. Any date, my lords.
ಕಾಲ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್. ಎಂಟ್ರಿ ಮಾಡರ್ ಟು ಎಂಟ್ರಿ ಮಾಡರ್ ಇದೆ. All right.
Grateful.
Yes, Suryanarayana.
Just to recapitulate, my lord, I had taken your lordships through the scheme and object of the act of the Karnataka Value Added Tax Act, which basically says that it's a value added tax act. Earlier, multi-point tax has been shifted to single point tax. And there should not be any cascading effect, and therefore, whatever tax.
Question is whether claim for input tax concession should be made in the return itself, or it can be raised independently. That was the basic question.
That's the basic
that.
question. If not made in the return,
Ah.
can it be
refused?
denied?
Denied.
If I made the claim before the assessing authority,
Dehar's return,
dehards the return, if I made such claim before the assessing authority during assessment, can such claim be denied just because I have not claimed it in the return? That is the question which
he banked upon rule 33, no? Other one,
he is banking upon a judgment of this honorable.
no,
court
rule,
in the
other
case
one
of-
particular rule.
38.
Rule
30?
38.
Rule 38.
38.
My
Yes.
argument is that 10, 35 and Rule 38 are composite in nature.
10,
Section 10, Section 35 and Rule 38 are composite in nature.
What I had submitted, taking your lordships through the scheme and object of the act
yes.
and section 10.3, 10, section 10 basically, which basically says that to compute the net tax payable, output tax must be reduced by the input tax that I have paid on my purchases, and my tax liability is only the net tax payable. Therefore, input tax is basically.
You took us through form 100 or something.
That is, I'll come to that. I'll come to form 100. Form 100 basically is the return which is to be filed under section 35, which my learned friend is relying on. All right. I had taken your lordship, if your lordships recall, the scheme and objects of the act. The scheme and object of the act is that they are shifting from multi-point levy, which was under the original
Old regime.
KST Act. And coming to single point levy, and to avoid cascading effect of taxes, because it was becoming tax on tax. Therefore, they wanted to avoid cascading effect. And to achieve that objective, they are giving an input tax credit, which is basically a credit of the taxes that I have already paid on my purchases, because those purchases ultimately go into my sales. So my output tax liability is minus my input tax liability, which is basically in the nature of a tax credit, akin to a TDS in the cases of income tax. That cannot be derived by missionary provisions like section 35 read with rule
You can't
38.
take TDS and also again levy the tax, is your basic.
Correct. You have
idea.
already collected the tax. That tax is my tax. Tax that I am liable to pay, you have already collected that in advance. Merely because by mistake or by error, I have not claimed it in the return, you cannot deny me that credit. That's the, and section 10 I have read to your lordships. Section 10 vis-a-vis input tax credit says that input tax credit is subject to the restrictions under section 11, 12, 13, 14, 17 and 18.
And nothing else.
And nothing else. If I don't fall under section 11, 12, 13, 14, 17 and 18,
You can't invoke rule.
you can't invoke something else. You can't read into the act something else to deny me that credit, unless it is specifically provided for under the act, which is not the case here. Section 35 does not say that my input tax credit will be denied if I don't claim it in the return. Neither does rule 38. Now, when we were reading rule 38, my lord, your lordships asked, what is the rule making power? And we took your lordships through. My learned friend read section 88. And there, we'll start from there. If my lords kindly see section 88 of the KVAT Act.
It provides for,
Rule, 88 is power to make rules.
that we have read another day.
We have read.
Yes.
And my learned friend, relying on subsection 4 of rule 88.
The other rule 88 is the whole repository of delegation power.
Yes,
There is no other provision.
there is no other provision.
No word is used, prescribed, etc.
Prescribed, the section 35 says return to be filed as prescribed.
That itself amounts to delegation of power is the apex condition.
That is one. But my learned friend took your lordships to subsection 4, and your lordships had a doubt. Your lordships wanted us to examine that point.
Now, let us go to the section
35.
35.
Yes.
Let us read 35.
Yes.
ಇದು ಟ್ಯಾಕ್ಸ್ ಹೊಸ ಸಬ್ಜೆಕ್ಟ್ ಇರೋದಕ್ಕೆ ನಮ್ಮನ್ನು ನೀವು ನಿಧಾನವಾಗಿ ಕರ್ಕೊಂಡು ಹೋಗ್ಬೇಕು.
Yes.
ಅದರ್ವೈಸ್ ನಮ್ಗೆ ನಮ್ಮ ಕೈಯಿಂದ ಆಕ್ಸಿಡೆಂಟ್ ಮಾಡಿಸಬಾರ್ದು. You have to take us very slow.
Yes.
We are not that, at least I do not have much exposure. My brother may have. 35 ಅಲ್ಲ?
Yes.
Returns.
Returns, subsection 1. Subject to subsections 2 to 4, every registered dealer and the central government, a state government, a statutory body and a local authority liable to pay tax collected under subsection 2 of section 9 shall file a return in such form and manner, including electronic methods, and shall pay the tax due on such return within 20 days or 15 days after the end of the preceding month or any other period as may be prescribed. So what is prescribed is only the form and manner of filing the return. Rule 38, which my learned friend read, which is the rule prescribed under section 35(1). Rule 38 is only the form and manner of filing the return.
It does not say anything else.
It does not say anything else. And 35 nowhere else says.
Let us see that too.
Rule 38, my lord, yes. Rule 38, submission of monthly returns.
Every registered dealer.
Every registered dealer shall submit a monthly or quarterly return as the case may be, containing value of sales, purchases, and other transactions, input and output tax claimed or collected, and net tax relating to all of his places of business,
etc., etc. But
etc.,
ಅಲ್ಲಿ
etc.
input tax and output tax ಎರಡು ಇದೆಯಲ್ಲ.
There, but that is only pertaining to form of return. What section 35 says is, it says what is to be prescribed is the form and manner of filing the return.
Please read 35(1).
Yes. Subject to subsections 2 to 4, every registered dealer and the central government, a state government, a statutory body, and a local authority liable to pay tax collected under subsection 2 of section 9 shall furnish a return in such form and manner, including electronic methods, and shall pay the tax due on such return within 20 days or 15 days after the end of the preceding month, or any other tax period as may be prescribed.
ನೀವು ಹೇಳೋದು 38 transcends 35 parameters ಅಂತನಾ?
That's
To-
all.
to
It
the
only
extent-
prescribes the form in which the return has to be filed.
Form and manner ಅಂದ್ರೆ ಏನು English ನಲ್ಲಿ?
Form,
How courts have interpreted form and manner.
form is the form of the
Forms.
return, what all details you have to give in the return. Manner in which it has to be filed is
Form is-
prescribed.
Form is Riti, manner is Niti. That's how Ego Kannada says. So forms already prescribed, form
Correct.
100, etc., etc.
Correct. Which says input tax credit, you have to show the details of input tax credit.
But forms become part of the law.
Part of the law, no doubt. It has a statutory this thing, but it doesn't become the law and it cannot override or it cannot prescribe any new condition which the act does not have. So one, I read section 35 and said section 35 itself does not prescribe any restriction that if I don't show anything in the return, that cannot be claimed. I have lost the right to claim any benefit that I have not claimed in the return forever. That right is lost forever.
Third question of law would be two questions perhaps. Whether section 35, section 35
Yes.
read with rule 38
Imposes any restriction.
imposes any restriction for claiming input tax concession,
If not claimed in that return.
such as claim has to be made only in the return. Number one. Incidentally, question would arise whether requirement of claiming input tax concession only in the return can be read into rule 38. If so, whether that part transcends parameters of section 10.
Object or scope of the act itself. Any
Section
provision.
10, section 10.
Section 10.
Return.
Correct.
These
Now,
will be. two
therefore, your
questions.
lordships asked what was the rule making power. Now, I have read rule 38. Kindly see section 88. Section 88 gives power to the
Rule making
state,
power.
the government to make rules, and the rules have been made under that. Now, kindly see
So
subsection.
why we should go there?
No. Because my learned friend pointed out subsection 4 and said his argument was that the rule 38 itself has a statutory, it's virtually a statutory provision. So it can make any condition, impose any condition which is contrary to the act also.
As if it is no, contrary. What he said is, legislature in its wisdom said, a rule made under these shall be treated as if they are the act.
as if they are the act.
Ah.
So what is the meaning of that?
Correct. That
And
I wanted.
does that mean that a rule can override a provision?
It cannot.
One, or can a rule prescribe something which goes against the object of the act? That is what we are looking at.
Answers are in
Assuming-
administrative law, answers are obviously in your favor,
Correct.
but it's not that simple.
But that is not the argument, my lord.
No,
He's
no.
answering an
I'm
argument I have not
saying
raised.
My point was, first, Rule 38 itself does not prescribe any restriction.
Perhaps others may not wait. Come in the afternoon. This will take some time, Mr. Rajgopal and sir. May not, you also may not wait.
With regard to the next matter, your lordship suggested that a mediator be appointed, your
Howದು.
lordship.
ಹೌದು.
Madam,
ವಿ ಆಚಾರ್ಯ ಅವ್ರನ್ನ ನಾವು
yes,
ರಿಕ್ವೆಸ್ಟ್ ಮಾಡಿದ್ವಿ.
he has kindly accepted. We have filed our respective synopsis. And the learned mediator is seized of the matter. So we thought that we will mention it, and about 3 weeks' time we.
3 weeks.
Yes.
ನಿಮ್ಮ ಫ್ರೆಂಡಿಗೂ ಮಾತಾಡಾಗಿದ್ಯಾ?
ಹೇಳಿದ್ದೀನಿ ಅವ್ರು.
Don't tell. Okay, call after 3 weeks.
We don't want to
Since-
trouble your
ಏನ್
lordship
ತೊಂದ್ರೆ?
further.
Since mediation is halfway through.
3 weeks.
3 weeks ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ ಜಿಕೆ. ಅದೇನೋ ಮೀಡಿಯೇಷನ್ ಆಗ್ತಾ
ಹೌದು
ಇದೆ.
ಆಗ್ತದೆ.
3 weeks ಹೋಗಿ.
ಅಲ್ವಾ?
ಅಲ್ವಾ?
ನಾವು ಸ್ವಲ್ಪ ಟೈಮ್ ಬೇಕು ಅಂತ ಹೇಳಿದ್ದಾರೆ.
ಅದೇ. 4 weeks ಮಾಡ.
ಅಲ್ಲ 3 weeks ಬೇಡ. 4 weeks ಬೇಡ.
Very well.
Both the learned senior advocates submit that the mediation process is halfway through and therefore matter be called after 3 weeks. First, we agree.
Great.
What I was submitting, my lord, is my learned friend's submission was, although section 35 does not prescribe any restriction, Rule 38 says that the return should contain these details, and Rule 38, yes, I agree that Rule 38 says that it should contain details of input tax credit. But it doesn't say, one, that if you omit.
Not made in the return, absolutely you cannot. That's not the intent of rule.
First of all, Rule 38 doesn't say that. Assuming says that.
Then
it
what
not
it-
be.
One second.
Yes.
What Rule 38 does not say?
It doesn't say that if I don't claim it, show it in the return.
Negate it.
It goes, I cannot claim it before the assessing authority or the appellate authority. It doesn't say that. Because as I pointed out, section 10 itself says what are the restrictions for claiming input tax credit. If any other restriction has to be added to that, that has to be specifically stated so under the provisions of the act. Provisions of the act, including section 35, does not say that if I don't claim the input tax credit in the return, I cannot claim it forever. It doesn't say. Now, does the rule say that? According to me, the rule also doesn't say that. Assuming the rule says that, because it says it should contain so and so details. Assuming that is taken as a restriction, will it not be against the object of the act itself? Will it not be falling foul of section 10 and the scheme and scope of the object? Can it? Now, because of subsection 4 of section 88, which says that rule is as if it is enacted in this act, as if enacted in this act. Your lordships wanted to know what is the meaning of as if enacted.
How Supreme Court has stated
Yes.
that?
So in fact, our High Court has referred to GP Singh interpretation and the Supreme Court has and said, even then, even if those words are used, it cannot be that a subordinate legislation
Would the
can.
status of the statute
Yes,
itself.
yes.
That is in the case of either virus or repugnancy.
There is repugnance.
There is no contest.
If
It is
you say-
neither outside virus nor repugnancy.
So effect has to be looked into, not validity at all antana.
There is no.
A question illela.
If the question, my lords, if it is before parliament or legislature, the compass is the constitution, the 3 lists, whether legislative competence is there or not. Once it comes to subordinate legislation, the compass is the statute in addition to the constitution. Now, I am not for a moment canvassing that by rules, he can do something that the statute does not contemplate or the constitution does not contemplate. That would obviously, it has to be treated as subordinate legislation.
No, what Surnarayana says is section 10, 11 up to 18. Whole parameter is fixed.
Let me make this concession, my lord. If your lordships find that 38 is repugnant to the act, then yes, it has to fall. It will not be elevated to another pedestal, although because of
Enactment, as if enacted
Ah.
through.
yes, but what my submission was in the light of various submissions that were made, saying that A, it is a machinery provision. So I am saying there is no, if your lordships do not find repugnance, there is no hierarchy, is the submission. And by analogy, it was said that the tail.
Question of repugnancy ಇದ್ದಾಗ ಮಾತ್ರ hierarchy ಹೇಳ್ತದೆ. Otherwise conflict ಪ್ರಶ್ನೆನೂ ಹೇಳಲ್ಲ ಅನ್ನೋದು ನಿಮ್ contention.
ಹೌದು.
But just one question, because what he says is, whatever limitation or restriction you want to enact, the state has already enacted it. In substantive provisions in the act itself.
Yes.
You cannot overdo something. And if at all you have done if you have overdone something by this rule,
Absolutely.
that should be treated only as directory, because
Absolutely.
no provisions say, including rule 38, that in the event claim is not made in the return itself, the claim shall be disallowed. ಅನ್ಕೊಂಡಿಲ್ಲ ಅಂತ ಅವ್ರದ್ದೊಂದು contention.
Absolutely.
ಇದರಲ್ಲಿ
If your lordships find it is overdone.
Of conflict, other things arise only when they compete with each other. If there is no competition between these two,
Precisely.
where is the question of this anta ನಿಮ್ಮ answer?
Precisely. Precisely. If it is.
They can coexist and cooperate.
Coexist, cooperate. The provision of 10, the calculation required under 10 is being effected in rule 38. I will take your lordships to section 38. The
Rule 38 language ಹೆಂಗಿದೆ ಓದಿ ನೋಡು.
Yes.
Mandatory type ಇದೆಯಾ language?
Filing of the return is mandatory. If I don't file the return, there's a penal provisions also. There are penal provisions if they don't file the return in the time prescribed and in the form prescribed.
The idea of mandatoriness itself admits so many shades.
Correct.
It itself will admit so many shades. From that angle, so far as filing of return, it may be mandatory.
Yes.
So far as the form into which you are filing it may not be mandatory. That period within which you have to file may not be mandatory. Filing as such is mandatory. Nobody can dispute that, because tax and death are two things that are inevitable.
Correct.
So you have to be inevitable. But how rule 38 is structured?
Yes.
Just read it again.
Submission of monthly returns. Every registered dealer shall submit a monthly. I'm sorry.
Correct. Submission of monthly
returns. Every registered dealer shall submit a monthly or quarterly return as the case may be, containing values of sales, purchases and other transactions, input and output tax claimed or collected, or net tax relating to all of his places of business, and accompanied by proof of full payment of any tax due, including any certificate of deduction of tax at source, and a statement containing the details of purchases made within the state from other registered dealers, in respect of which he is liable to claim deduction of input tax, and sales of taxable goods made to other registered dealers in the state to the jurisdictional local VAT officer or VAT sub-officer in form VAT 100 within 20 days after the end of the relevant month where the tax period is a calendar month, or 15 days after the end of the relevant quarter where the tax period is a quarter.
Proviso ಏನದು?
Provided that any registered dealer unable to furnish any certificate of deduction of tax at source along with the return in form VAT 100 shall furnish such
ಇದೇನು
certificate.
Input tax ಇದು?
No, this is tax deducted at source. So some contracts that
they are deducted and paid.
For the government is liable to deduct tax.
So not concerned with our
We are not
question.
concerned. Provided further that the form and monthly return, form of monthly or quarterly return in respect of dealers liable to pay tax under subsection 4 and 5 of section 4, including any tax liability under subsection 1 of section 4 shall be in VAT 105.
Idenidu?
That's basically, my lord, applying to dealers who are covered by subsections 4 and 5 of section 4. It does not apply here. Form VAT 05, it's a different form prescribed.
Any format for input tax concession claim ಮಾಡ್ಲಿಕ್ಕೆ format ಏನ್ರ ಇದೆಯಾ?
Return ನಲ್ಲೇ ಇರುತ್ತೆ. VAT 100 ನಲ್ಲಿ, we have to fill the details of my purchases, sales, what is the value of purchases, what is the value of
They
sales.
themselves have to work out that.
No, I have to work out that.
You
I have to work out that and file the return. And under section 38, once I file the return, it's a case of self-assessment. It is deemed to have been accepted. But under section 39, the assessing officer has the power to do a reassessment. Because there's already a deemed assessment, it's called a reassessment. Section 39, once he takes up a reassessment, the point is, let us say something I have not claimed in the return. Can I not claim it before the assessing officer during the course of the assessment? Now, what is the assessing officer's duty? Assessing officer's duty is to assess the correct tax liability. Not just assessment, he cannot just mean only in cases where he wants to increase my tax liability. If he has the power to increase my tax liability, power to decrease my tax liability is also equally there on an assessing officer, because that's the duty of the assessing officer.
If it goes to reassessment.
If it goes to reassessment, these are all cases of reassessment. For example, my lord, my learned friend may be right if I file a wrong return, if I file a incomplete return by not claiming this thing, and because by virtue of section 38, there's a deemed assessment. Assessment under 39.
He may be right.
There he may be right because there is no reassessment in that case. So I cannot make a claim before the assessing officer and say, because I cannot voluntarily tell the assessing officer, you take up this matter for assessment so that I can make this claim, because it's already deemed to be assessed. But if 39 assessment is taken up, I have every right, because he's taking up to assess the correct tax liability. Once he's taken up the matter under reassessment, his duty is to compute the correct tax liability. And not just increased tax liability.
Therefore, necessarily he has to give this
even
deduction.
If I have by mistake not claimed it in the return and I make such claim before the assessing officer during the course of assessment, he is duty bound to give me the benefit which is provided to me under the act. That is what the courts have said. Because the courts say there is no doctrine of estoppel. Doctrine of estoppel doesn't come when the act gives you a benefit that merely because you have not claimed it. Yeah, courts have said that on a benefit that is available to you merely because you have not claimed it in the return, there cannot be a doctrine of estoppel for you not to claim it.
Courts esto sari bada loose language upekstare. Alli estoppel kinta, because estoppel is contemplated under section 114, 115 of Evidence Act.
Correct.
Adu estoppel alla.
That estoppel is different. No, this is loosely. I mean, my lords are right. Loosely.
Correct helbeku andre waiver aglik bartittu. Estoppel mele Indo-Afghan snow, etc. judgments are there that under sugar mills versus so and so. They treat estoppel entirely. All literature na fit in agala. Anyway, judges we use sometimes very loose English we use, and that creates problem. At the most, they could have said waiver anta helik bartittu.
Correct.
Anand bitbitanpa waiver agi hogtadu. For example, order 2 rule 2 CPC, where you do not claim, you could have made a prayer, but you do not make the prayer in your plaint. Therefore, you are deemed to have waived it ಅನ್ನುವಂತ ಕಾನ್ಸೆಪ್ಟ್ ಇದೆ.
Correct.
ಅದು ಇಲ್ದಲ್ಲಿ ಎಲ್ಲೂ ಇಲ್ಲ ಅಂತ ನಿಮ್ಮ ಕಂಟೆನ್ಷನ್.
ಹೌದು.
ಒಂದೇ ನಿಮಿಷ. I'll articulate the point. Mr. Suryanarayana submits that. Section 10 mandates filing of the return. Correct?
Yes.
Semicolon. The form and manner are prescribed in Rule 38,
35 mandates.
Section 35.
35 mandates.
Mandates
I'm sorry.
filing of return. Semicolon. Rule 38 prescribes the form and manner of this return, semicolon. It is true that there is requirement in terms of Rule 38 of mentioning the input tax concession, if at all it is there. Semicolon. This rule cannot be treated as providing for rejection of input tax claim concession if it was not mentioned in the return. Full stop. An argument to the contrary would be contrary to, would be repugnant to the policy content of sections 10, 11, up to 18. 10 to 18. 10 to 18. Full stop. He hastens to add that the Act provides for self-assessment, and in that case, arguably, the requirement of mentioning input tax concession may be there, semicolon. However, when statutory reassessment is undertaken by the authority, the object is obviously to assess the correct amount of tax and collect it. Therefore, there is a statutory duty to grant input tax concession even if the same is not mentioned in the return, provided claim is made separately within the period of limitation.
Within the period of limitation, illa, because
my
claim, yes.
How can that?
No, assessment is a continuation of proceedings. Appeal also is, in fact, the courts have said even before an appellate authority, you can make the claim. What you have not claimed.
ನಮ್ಮಲ್ಲಿ ಬಜೆಟರಿ ಎಕನಾಮಿಕ್ಸ್ ಇದೆಯಲ್ಲ, ದಟ್ ಈಸ್ ಎನಾಕ್ಟೆಡ್ ಇನ್ ದ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್. ನೀವು ಪ್ರತಿ ಗೌರ್ಮೆಂಟ್ 5 years ಎಲೆಕ್ಟ್ ಆಗಿತ್ತು, ಅದಕ್ಕೆ ರಿಸೋರ್ಸಸ್ ಎಷ್ಟು ಬರಬೇಕು, ಎಷ್ಟು ಹೋಗ್ಬೇಕು, ಇದೆಲ್ಲ ಆಸ್ಪೆಕ್ಟ್ ಇದೆ. ನೀವು ಈ ಒಂದು 25 ವರ್ಷದ ಹಿಂದಿಂದು ಎಲ್ಲ ಲಿಮಿಟೇಷನ್ ಇಲ್ಲ, ನಂಗೆ ಅದನ್ನು ಕೊಡಿ ಅಂತ ಹೇಳಿದ್ರೆ ಆ ಗೌರ್ಮೆಂಟ್
ಅಸೆಸ್ಮೆಂಟ್ ಇಸ್ ಓಪನ್,
ನಾಟ್ ಕನ್ಕ್ಲೂಡೆಡ್. First stop. He goes one step further in saying that although there is no limitation for making the claim of input tax ITC, if that is made within the period in which the reassessment proceedings are concluded, the claim cannot be negated.
In fact, I would go one step further to say, because appeals are continuation of assessment proceedings, even under, and courts have said so. I'm not saying this on my own. The courts have said that even before appellate authorities, you can make that claim.
He goes 2 steps further in saying that the assessment proceedings are deemed to be not closed as long as the statutory appeals are pending.
Not all statutory appeals, up to fact-finding authority. Obviously, when we come before your lordships, it's only a question of law. I cannot perhaps say that I'll raise a fresh claim, which I have not raised it before the fact-finding authorities, before your lordship.
Appeals before the authorities are not are pending.
Appeals before the
if not tribunal and court.
Tribunal fact-finding authority, and it's a continuation of appeal.
Appeals are pending before the authorities or the tribunal.
For this purpose, my lord, I'll just,
ಅಲ್ಲ ಒಂದೇ ಸೆಕೆಂಡ್
yes,
ನೀವು ಲಿಮಿಟೇಷನ್ ಹೇಳಿದ್ರಲ್ಲ ಈಗ ಸಿನ್ಸ್ he said that there is no limitation at all ಅಂತ
it was introduced in 2015.
where from you are bringing the limitation?
In 2015, for the first time, they have introduced, and this court has said that proviso is prospective.
ಇದು ನಿಮ್ದಕ್ಕೆ ಅಪ್ಲೈ ಆಗಲ್ಲ
From the 2007-8,
7-8
7-8, 8-9, 7-8, 8-9,
before
9, 9-10, before the amendment.
First off, he also points out the section, amendment section,
10-3, proviso.
section, the proviso to section 10.3, which prescribes a limitation period, and that a coordinate bench of this court has held it to be prospective, and therefore it does not apply to the petitions at hand. If you have enacted limitation for the first time, Mr. Aditya, if you have enacted limitation for the first time in 2017, 15, then you can't take it to the other proceedings.
And on the point, my lord,
It says retrospective or prospective. He says court has held that it
our
is
court has
prospective.
held and affirmed now by the division bench and Supreme Court. That's the judgment which I read, Kirloskar, Sonal Apparels and PML.
The citation.
I have passed it on.
ಅಲ್ಲಿ ಹೇಳಿ
last-
ಹೇಳಿ ಯಾವ್ದು ಅಂತ
I'll just give Sonal is one.
ಬರ್ದ್ಕೊಡಿ ಸೊ ದಟ್ ಇಲ್ಲಿ ನಮ್ಮ ಇವ್ರು ಬರ್ಕೋಬೇಕಲ್ಲ.
I'll just pass on this judgment of Justice Anand Reddy. 1 minute. This I had not passed on. I had given there BML, which I cited on the last occasion, division bench, which affirmed Kirloskar, also affirmed Sonal Apparels. If my lords kindly take Sonal Apparels.
ಅಲ್ಲ ಅದು ಪ್ರಾಸ್ಪೆಕ್ಟಿವ್ ಅಂತ ಹೇಳಿದ್ ಒಂದು ಸೆಂಟೆನ್ಸ್ ಇರುವ
ಹೌದು ಇಲ್ಲಿ it is in paragraph.
Like it says it's clarificatory in nature.
ಯಾವುದು
Sona.
clarificatory of limitation period.
The apex court has held that clarificatory or declaratory amendment is generally passed in order to rectify what the legislature deems to
They
have
are
been
retrospective always.
In case, no. In case on hand judgment in centum so-and-so was rendered in less than a year, the legislature amended 10.3 declaring that the dealers are permitted to avail.
Ma'am.
The newly substituted provision clears the air and puts to rest. It may hence be said that the amendment under 10.3 is clarificatory and therefore could be given retrospective effect.
Precisely. It is not possible.
Petitions are accordingly allowed and shall be read.
Retrospective ಅಂತ hold ಮಾಡಿದ್ದಾರೆ.
Yes.
Because always procedural law. This is what our Professor Seshadri and Professor Vishweswaraya used to teach us. All substantive amendments are prospective. All procedural amendments are retrospective unless the statute otherwise says. Therefore, it will be applicable to you also.
It will be applicable if for this, the case being dealt with was a case of.
ಅಲ್ಲಿ held to be prospective ತೆಗೆದು held to be retrospective.
My lords may kindly read, allow me to read para 34 onwards of this, the context in which they said it is. Paragraph 34.
Of
Sonal Apparels.
what is it? ಯಾವ judgment? Sonal.
This judgment also, my lord, was affirmed by BML, which I cited on the last occasion, apart from Kirloskar. Para 34 onwards.
On a consideration of.
On a consideration of the above rival contentions, it is noticed that the object of the KVAT Act, as is evident from the statement of objects and reasons of the Act, which I read on the last occasion, is to avoid the cascading effect of taxes and consequently to reduce the quantum of taxes embedded in the price of goods. This is obviously achieved by allowing the purchasing dealer to deduct the tax paid by him on his purchases. That is the input tax from the tax payable on his sales. That is the output tax, while calculating the net tax liability.
ನೀವು ಎಲ್ಲಿ ಯಾವ ಕ್ವಶನ್ ಮೇಲೆ ಇದ್ದೇವೆ ನಾವು?
This
Whether
is,
it is retrospective or prospective, ಅದ್ರ ಮೇಲೆ ಹೇಳಿ.
No,
ನಂತರ ಮುಂದೆ we'll go to
I'll
the.
come to that. In what context that came, why the amendment? Because that amendment was made when this judgment was reserved. This matter was heard and the amendment was brought in to get over this judgment. And by the time the judgment was pronounced, this amendment came, then the state moved the matter and brought this amendment to the notice of the courts. Therefore, it is, I'm just reading this. It may be quite possible that if section 10.3 is to be interpreted to mean that a dealer is permitted to take credit of tax paid on purchases only in which the selling dealer raises invoices, it would result in possible situations where credit cannot be availed by dealers for practical reasons as cited by the petitioners. The scheme of the KVAT Act being to provide for set-off of all tax paid at earliest points of purchase against the tax payable by him on his sales by compelling a dealer to avail of credit of tax paid on purchases only in the month in which the selling dealer raises invoices, the scheme would be defeated and it may result in double taxation. This is what Centum also says. Centum says you have to claim it in that period. This court does not agree. And under the provisions of the erstwhile Karnataka Sales Tax Act, the 1957, tax was leviable only at the stage of first sale of goods. Under the KVAT Act, tax is leviable on every sale of goods, irrespective of whether it is first, second, or third sale. However, in order to ensure that the Act does not fall foul of the prohibition placed by the Constitution of India on double taxation, the provisions of the Act permit a dealer to deduct the amount of tax paid by him on his purchases while calculating the net tax liability. If the interpretation afforded by the revenue to the meaning of section 10.3 were to be accepted, the petitioners would be deprived of the benefit of availing credit of input tax paid on their purchases. It would result in tax being levied under the provisions of the same Act on the same commodity at multiple stages. In Centum Industries case, this court has interpreted section 10.3 to mean that a dealer is required to avail credit of input tax in the month.
Come to 39.
39. On the other hand, in Manyata Promoters case, a division bench of this court has categorically held that the provisions of the Act do not require a dealer to avail of credit only in its returns filed for the month in which the purchaser's invoices are raised by the selling dealer. A contention on behalf of the revenue that a dealer is permitted to avail of credit belatedly up to 6 months by revising the return under section 35(4) of the Act, apparently drawing inspiration from the decision of Centum Industries, is not relevant. It would not be possible to hold that section 10.3 first restricts availment of credit to the same month as the month of purchase, and then section 35(4) goes on to permit the same by way of revision of return would be an absurd construction. Such an interpretation would lead to the conclusion that the KVAT Act encourages availment of credit by the dealer without ensuring the eligibility for the same, as delay in availment would result in denial of credit altogether and thereafter rectifying any incorrect credit available by revising the return. Such a view could not have been the intention of the legislature, as that would lead to a situation where filing of a revised return under section 35(4) would become a rule rather than an exception. In other words, every dealer may be necessarily required to file 2 returns for the same tax period, firstly an original return reflecting incorrect credit and then a revised return availing the eligible credit. A case can be found in favor of the petitioners in the alternative as well. In that, it is not in dispute that from the inception of KVAT Act, section 10.3 was consistently interpreted by the revenue to mean that a dealer is permitted to deduct the input tax paid on his purchases irrespective of the month in which the purchases were effected. Based on the understanding that section 10.3 did not require dealers to avail credit only in the month in which the purchases were effected, they were held entitled to avail of such credit as long as the claim of input tax credit was supported by the prescribed documents. The ambiguity as to the purport of section 10.3 arose as a result of the department's clouded interpretation of the Centum Industries case. The newly substituted provision clears the air and puts to rest the ambiguity. It may hence be said that the amendment to section 10.3 is clarificatory and therefore could be given retrospective effect. The apex court has held that a clarificatory or declaratory amendment is generally passed in order to rectify what the legislature deems to have been a judicial error. In the case on hand, the judgment in Centum Industries was rendered in so and so, and in less than a year, the legislature amended 10.3, declaring that the dealers are permitted to avail credit of tax paid on so.
That's the judgment.
Yes.
This judgment in so many words does not say that input tax concession or credit can be claimed even when it is not mentioned in the return. It is more on the limitation period.
It is more on the limitation, correct. And then I read Kirloskar also, my lord, which says that 10 is a substantive provision, 35 and other provisions are missionary provisions. Missionary provisions cannot take away
Override.
right of substantive provision. These two judgments,
Hello,
tonal
we'll come
apparels.
We'll come to that one.
Now,
First,
so
let us
now-
understand this judgment.
Correct. This
Do you
judgment
agree
basically lays
that
down the
this
scheme.
judgment is more on limitation period
Limitation period.
and retrospectivity of the Amendment Act.
Correct.
ಎರಡು aspect ಮೇಲೆ ಇದೆ.
ಹೌದು.
Perfect. There is a,
And
do
it
you
is
disagree with our view?
not at all, my lords. I'm just saying, factually, it is not his case that he has claimed it in any return.
No, that is the reason he is arguing. That is his very case.
Correct. I need not claim it in the return itself.
Return at all his case. Perfect. There is a broad consensus at the bar that the learned single judge's decision in Sonal Apparel 2016 SEC Online Karnataka 9410 did not specifically consider the question as to whether the ITC benefit can be claimed only if it figures in the return or revised return. Semicolon. There is also consensus that the judgment broadly spoke of the limitation period within which ITC should be claimed. And that the 2015 amendment to section 10.3,
Yes.
10.3 of the Act being declaratory stroke clarificatory in nature is retrospective in operation. This we
Now
have
kindly see the proviso which
Aye.
was introduced by this amendment, which was the subject matter of this judgment. Why this proviso was inserted to get over Centum? In fact, this proviso watered down Centum, because Centum, as your lordships have seen, Justice Kumar said, you have to claim the input tax credit in that period, because the term used in 10.3 is in that period. So the year in which, in the month in which you raise the invoice, now the purchase seller or you purchase the goods, in that month only you have to make the claim is what Centum said.
of division bench.
Of division bench. That's been watered down by this amendment to say, kindly see the proviso to amendment, section 10.3.
Provided it is there in the return.
It doesn't say that.
Section 10.
Provided 10.3 proviso.
But ನೀವಿಬ್ರು ನಮಗೆ ಭಾಳ lot of class ತಗೋತೀರಿ. Really, I tell you, we learn so much.
Proviso to 10.3. 10 subsection 3 proviso. My lords have it.
Subsection 3 ಇದೆ.
ಅದು ಕೆಳಗಡೆ proviso. ಇಲ್ವಾ? That must be a old book.
Old book ಇದು. 2004. We are always very old. We go in reverse gear.
May I pass on?
Lords, I would submit that the old book is required because
ಅಲ್ಲ,
I will-
because ಆಯಾ years ಬರ್ತದೆ.
because I will be making some submissions on
Based on this.
on that 15-16 amendment. I'll be making some submissions. So let's
Okay.
Proviso.
Proviso ಓದಿ.
The proviso says, provided that a registered dealer, while calculating the net tax payable on or after first day of April 2015, may claim may claim input tax relatable to goods purchased during the period immediately preceding 5 tax periods of such tax period, if input tax of such goods is not claimed in any of such 5 preceding tax periods. That's all the proviso says. If I'll give an example.
In other words, proviso is not applicable to you at all.
Precisely. This proviso does not.
ಅದಕ್ಕಿಂತ ಮೊದಲಿಂದ ಹೋಗ್ಬಿಡತ್ತೆ ನಿಮ್ದು ಅಂತ.
This proviso does not impose any restriction to claim input tax credit first. It only says, because Centum was before this proviso, and within the 1 year of Centum, this proviso was introduced. Centum said, let us say in April, you purchase some goods and an invoice is raised. When I purchase goods, I make payment, make payment of input tax also. That is the input tax which I take credit when I sell the goods. Those goods, or I use those goods in manufacture and sell. In the month in which you raise that invoice, or in which you pay the input tax credit itself, you have to claim the input tax credit, is what Centum said. Now, by way of this proviso, what the government has done is, it has diluted, because it's practically impossible to do that. Because what happens, my lord?
To some extent, it is in favor of the dealer.
It is in favor of the dealer, because let us say, my lord, I purchased the goods on 30th April. Goods have come to my godown, but I would not have accounted that invoice in my account books. I would have accounted that invoice in my account books on 5th of May, 10th of May, or 1st of May, whatever, in the next month. Or for another example, the goods have come to me. Invoice has been raised. I have paid for that. But the goods are defective. I return the goods. This invoice I don't pay unless he replaces me the good. He replaces the goods 6 months later or 1 year later. I account the invoice 1 year later or 6 months later. It is the month in which I account the invoice, it will reflect, the tax will reflect in my books, because these are all basis my accounts. And until it reflects in my books, I cannot file a return and say, because I may have paid the amount, but until I show it accrues in my books. The concept of accrual and payment, cash basis, every dealer follows cash method or mercantile method. The basis that he will account for the invoice in the manner his accounts is required to be maintained under the Income Tax Act. So so to get over these difficulties, because Centum said you have to claim it in the month in which you have paid the input tax credit, this amendment was brought in to benefit.
It would have been impossible. So it facilitates claim for ITC.
For a delayed period also. But even this proviso does not restrict. This does not say, anywhere refer to a return first of all. And it does not say that if you don't claim it in the return, your claim is gone. That restriction has never been imposed. That is what we are on that point. Whether my claim goes merely because I have not claimed it in the return. Now, my lords may kindly see, and I have said, once a assessment is taken up, it is the duty of the assessing officer to compute the correct tax liability. And if not the assessing officer, even the appellate authority whose powers are coterminous with that of the assessing officer, even there I can make the claim, and that is what 3 judgments of this honorable court have said from 1967 onwards. My lords may kindly take this decision of this honorable court of 1967 first. Giridharilal Parasmal, which was followed by a division bench of this honorable court in my own case, Justice Alok Parade's judgment, which I cited at the first instance. It's a very short judgment. I'll read just to give the context in which this decision was given. I'll just read the entire judgment if your lordships permit.
Yes, read.
The petitioner, who is a dealer in cloth of different varieties, some of which are entitled to exemption from sales tax, made a return in respect of his turnover for the financial year 1958-59, showing gross turnover of rupees so-and-so, out of which turnover of rupees so-and-so alone was shown as liable to tax. The commercial tax officer, after looking into the accounts and examining the return, accepted the net turnover liable to tax to be rupees so and so and imposed tax as follows. The petitioner preferred an appeal to the Deputy Commissioner of Commercial Taxes and pleaded that the turnover of rupees 29,128, which was offered to tax by him in the return, taxed at 6% as shown above, was turnover which was entitled to exemption under entry 8A of the 5th schedule, and it was by mistake that he had shown it as part of the turnover liable to tax. The Deputy Commissioner refused to entertain this plea for no reason except that the petitioner had not brought this mistake to the notice of the assessing authority, and stating it as a proposition of law that it was not open to the SC to raise this point of exemption on an item on which no claim has been made by him before the assessing authority. The petitioner then appealed to the Sales Tax Appellate Tribunal. The said tribunal, after giving a long extract from the order of the Deputy Commissioner, disposed of the matter very briefly as follows. The only prayer, I'll skip that one out. Basically, appeal was dismissed. Hence, this revision petition. We have no doubt whatever, para 6, that the manner in which the taxing authorities have dealt with the matter is neither correct nor according to law. We find from the order of the original authority that upon inspection of the books, he found that the bulk of the turnover of the petitioner was not liable to tax, and that the turnover taxable was only in the neighborhood of 1,600. It is also clear.
Para 7 is very important.
Yes. When the facts are not disputed and the law is so clear, we fail to understand how the assessing authorities could not at all impose tax. Could at all impose tax.
We are
clearly of the opinion that the duty of the assessing officers is not merely to impose tax that is lawfully exigible, but also to give to the assessees the benefit of any reduction or exemption that may become due to them upon facts actually found to be true by the assessing authorities, whether or not the assessees, out of ignorance or by mistake, make a claim thereto. When the mistake is so obvious and the matter is taken up on appeal, we are of the opinion that it is the duty of the appellate authorities to correct the mistake. So they say not just the assessing authorities, the duty of the appellate authorities also to give them that relief.
Because duty is to assess tax.
Assess the correct tax liability. This, my lord, is subsequent another judgment of Justice Ravindran.
Yes, Chandra, yes,
2004.
Yes, a small judgment. So
short judgment and to the point.
Narayan Paigal hage idru.
This is reiterated again in 2004 by a division bench of this honorable court. This principle.
So whether you claim it or not, it is their duty. At least when I claim, they can't say, no, you have not asked it in your return, therefore we will not give you.
Unless there is a restriction under the
law
itself.
Rule 38 is the restriction.
Rule 38, according to me, there is no restriction. Even if there is a restriction, it goes against the principles of the act, scheme and object of the act itself.
Paragraph
Paragraph 12, my lord. The appellant at page, the last but one page,
does not dispute the fact that it voluntarily filed a return.
It had voluntarily filed a return offering the value of non-ferrous metal scrap brought by it into the local area to entry tax, and that it has paid entry tax on the said value, and that the assessing authority has accepted the return and passed the assessment order. But the question is whether the said action on the part of the appellant bars the appellant from challenging the order of assessment in appeal when once it realizes that the goods in question were exempt from tax. The question is covered by the decision of a division bench of this court in so-and-so, where an identical question was considered. The division bench held. I'll just read, my lord. I'm not citing that judgment separately because it's quoted here. The petitioner cannot ascribe any error.
Not stopped and precluded.
You are not stopped from making a claim which has been given under the act, even before assessing authority or before the appellate authorities. There is no question of invoking doctrine of estoppel is what the division bench has. And a more recent and more detailed judgment on this, of course, under the context of Income Tax Act, my lord.
Tax law estoppel restudicate apply ಆಗ್ತದ. apply ಆಗಲ್ಲ ಅನ್ನೋದು ಪಾಲ್ಕಿವಾಲಾ says. Correct. Are alien to tax jurisprudence. Doesn't apply. Does not apply at all. But still judgments use that way. Means it does not bar you from making the
Making a
claim.
claim,
ಅರ್ಥದಲ್ಲಿ.
which is otherwise given to me under that. This is more recent, my lord, by another division bench of this honorable court under the context of income tax, but pat on the point. In fact, this is a case where the SSE paid foreign tax. Whether that credit of that taxes should be given from the input tax. DTA provides for credit of the taxes that you pay in a foreign country in
That is
when you
double
pay
taxation.
taxes.
Double
Taxation
avoidance.
agreement, avoidance agreement. In that context, kindly see para 71. In this case, in the return, they did not make the claim. They made the claim for the first time before the assessing authority.
Revised return alva.
So the contention taken was they have not made the claim in the return. Like the contention here, they should have filed a revised return and claimed it. Having not claimed it in the return or the revised return, they cannot claim it.
That is repelled by the court. That is repelled by the court.
That is repelled by the court.
Paragraph?
Para 71 at page 28.
Revised return ಅಂತ heading ಇದೆ.
ಹೌದು.
But ಅಲ್ಲಿ rule position ಎಲ್ಲ ಏನಿದೆ ಅನ್ನೋದ್ರ ಮೇಲೆ ಡಿಪೆಂಡ್ ಆಗುತ್ತೆ.
But let us, what is the duty of the assessing officer is what?
No, that way on, it's
Yes.
the duty of the assessing authority to assess.
I'll just.
What is the tax payable?
Correct.
If excess is paid, he should refund. Whether I claim it or not ಅನ್ನೋ ರೀತಿ law develop ಆಗಿದೆ.
Correct. And that is again reiterated, my lord, is what I am saying.
Aye.
Kindly see para 71. It was contended on behalf of the revenue that no revised return was filed by the SSE under section 139(5). Here also the case is I have not filed a revised return under 35(4) of the act, claiming the relief under section 90 read with double taxation avoidance agreement. Only a letter claiming the said relief was filed before assessment and the same cannot be taken into consideration.
No, that was in the light of CBDT circular para 73.
Adu para 73 munche, what they say in para 72 is important. 139(5) of the act provides that if any person having furnished a return under subsection 1 or in pursuance of a notice issued under subsection 1 of section 142 discovers any omission or any wrong statement therein, he may furnish a revised return at any time before expiry of 1 year from the end of the relevant year or before completion of the assessment, whichever is earlier. The said provision refers to a return under subsection 1. Subsection 1 of section 39 provides for filing of a return of income on or before the due date. Furnishing a return of his income or the income of such other person during the previous year in the prescribed form and verified in the prescribed manner and setting forth such other particulars as may be prescribed. Even Income Tax Act, my lord, any tax enactment will have a form in which I have to file the return. If in such return, the SSE discovers any omission or any wrong statements therein, which has to be necessarily with reference to his income, or if it is sought to be corrected, then it could be done only by resorting to a revised return under section 139(5) of the Act. The income contemplated under section 139(1) of the Act can only be the income which the SSE bona fide believes to be his income and not the income as finally assessed by the assessing officer. On the discovery of omission or wrong statement in the earlier return filed by the SC, he can safely file a revised return without
He is not opponent.
without recourse to the SC. Correct. That's exactly what the High Court says. Once such a revised return is filed under 139(5), the effective return for the purpose of assessment is thus the return which is ultimately filed by the SSE on the basis of which he wants his income to be assessed. In this context, one should notice the issue on hand is not with regard to a claim that would vary the income of the SSE. The SSE issue is with regard to allowing a credit on account of tax paid outside India in respect of which particulars were furnished to the assessing authority during the course of assessment proceedings before the assessment is passed. It is bound to be entertained and dealt with on merits. Once the return is filed and the income tax officer commences the assessment proceedings, the assessing authority is not the taxpayer's opponent in the strictly procedural sense of the term. The assessment functioning involves the adjustment of tax liability of the SSE in accordance with the facts on record and in accordance with the law laid down by the legislature. The assessment is nothing but another name of adjustment of the tax liability in accord with the taxable event in the particular taxpayer's case. While determining the tax liability of the assessee, the assessing authority shall allow the credit of all prepaid taxes referred to in section 234B. The CBDT circular states to the effect that it is the duty of the assessing officer to make available to the assessee any legitimate and legal tax relief to which the assessee is entitled but has omitted to claim for one reason or another. Merely because the assessee in his return filed under section 139 has not put forth a claim for relief, he cannot be stopped from getting the tax relief if he is entitled to in law. The omission in the return filed under section 139(1) of the Act is not about non-disclosing of income. Income is disclosed. The omission is claiming tax relief out of the income which the assessee is entitled to under section 10A of the Act. Realizing this mistake before the assessment proceedings concluded, the assessee filed a letter putting forth such claim. Therefore, the assessing authority is legally bound to take into consideration the said letter, whether the assessee is claiming tax credit relief, and decide whether the assessee is entitled to such relief out of the tax liability of the total income in respect
So you
of
cannot
which-
say you have not said it in your return, and therefore, once letter is given, it should be acted upon on merits.
even if I have not made a claim in the return.
Same principle applies to your case and on them contention. Let us come in the afternoon.
Yes.
Aware judgment. Dispose of ಮಾಡಿಸ್ತೀನಿ ಕಳಿಸಿ. ಏನದು? ಇದ್ರ ಮೇಲೆ ಆರ್ಡರ್ ಆಗಿಲ್ವಾ? ಆರ್ಡರ್ ಸಪರೇಟ್ಲಿ ಮಾಡಿದ್ ನೆನಪಿದೆ ನನಗೆ. ಈಗ ಮಾಡಿದ್ರು. ಯಾಕಂದ್ರೆ ಮಾಡಿರ್ಲಿಲ್ಲ ನಾವು. ಇನ್ನೊಂದು ನಾವು ಮಾಡಿದ್ದೇನೆ.
Your lordship, submission, your lordship.
Yes.
Your lordship, serial number 38, can it be adjourned for 2 weeks, your lordship?
Yeah, which year, madam, it is?
Your lordship, it's from 2018, your lordship. Actually, the advocate handling this matter is not well. That's why I'm moving time from 3 days.
My lord, serial number 41, my lord.
41 ಯಾವ year?
Other side inform ಮಾಡಿ 2019, my lord. Vikram sir outstation ಇದಾರಂತೆ ಹಂಗಾಗಿ adjournment ತಗೊಂಡು. Any date, my lord.
Anyway, this matter will also go on, some important matter.
Date may be given, my lord.
For adjourning, no dates. If you want to argue the matter. Adjournment to ಕೇಳೋದು ಮತ್ತು date to ಕೇಳೋದು.
Oh, man. Thank you.
Much obliged, your lordship.
Idea. You're doing anything.
Court officer?
You won't have a time.
Court
to
officer?
This thing.
I'll just filter what I want.
Court officer?
He'll probably say written submissions. Whatever, if I give something in reply.
No, it's a debate. I can deal with it and finish it off.
Then it is never ending, no? Because my right is to close. If you argue again, then I will want to close. I don't know whether he.
No, ಅದಕ್ಕೆ I will deal with it. You conclude in your reply. ಅಷ್ಟೇ.
All right.
Writing something beforehand so that I will deal with it. You can have an opportunity to reply to that.
Court officer? Court officer? Court officer? Sir?
Madam, ಹೇಳಿ.
Serial number 38 adjourned, right?
2 weeks. You only mentioned no, madam.
Yes, it was not audible actually. Thank you, sir.
Hey, you can leave. Oh.
ಯಾವ್ದು ಗೊತ್ತಿಲ್ಲ.
$38 was ours now. We won't do it anymore. What is this circular? I have to reply to the judgment like this. ನೀವು ಬೆಳಗ್ಗೆ ಮಾಡಿದ್ರು ಅಂತ ಹೇಳಿದ್ರು, ಇದನ್ನು ಮಾಡಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ ನಾವು work ಮಧ್ಯಾಹ್ನ ಇದಾಗಲ್ಲ. ಇದು ಆಗತ್ತೆ, ಅಟ್ಲೀಸ್ಟ್ 1 hour ಆಗುತ್ತೆ, 1.5 hour. ಅದಾದ್ಮೇಲೆ ಏನೇನು ತಗೊಳ್ಳೋದು ಲಾಸ್ಟ್ ಟೈಮು ಎದುರು ನಮ್ದು ಆದ್ಮೇಲೆ ನಮ್ದು ಆಯ್ತು, ಆಮೇಲೆ ಮಾಡೋಣ ಬಿಡಿ. ಈಗ ಹೋಗ್ರಿ ನಾವು ಈ ಮ್ಯಾಟರ್ ಆದ್ಮೇಲೆ ಬೇರೆ ಮ್ಯಾಟರ್ಸ್ ಅದು 10:30ಗೆ ಅವಾಗ ಹೇಳ್ಬೇಕಾಯ್ತಲ್ಲ Yeah, not given above the record.
ಒಂದ್ಸರಿ ನೋಡ್ತೀರಾ? ಹಾ, PGS 1. Two weeks. ಇದು 23 ಮತ್ತೆ 24 ಡಿಸ್ಮಿಸ್ ಅಲ್ಲ, ಕಂಪ್ಲೀಟ್ ಡಿಸ್ಮಿಸ್. ಅವ್ರ ಅಪೀಲ್ ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ರು. ಅದು RTF ಸಮಥಿಂಗ್ ಇತ್ತಲ್ಲ ಅದು ಅವರಿಗಲ್ಲ. ಥ್ಯಾಂಕ್ ಯು.
By Lordship's permission, my lord. Serial number 35.
Ah.
It's a transfer pricing matter. It may be adjourned, my lord.
35.
35.
Sorry. 35. 2014 matter.
Is transfer pricing ಅಲ್ಲಿ
ರಿಮೈಂಡ್ ಆಗಿ ಬಂದಿದ್ದ ನೋಡಿ ಅಡ್ಮಿಟೆಡ್ ಆನ್ ದಿ ಸಬ್ಸ್ಟಾನ್ಷಿಯಲ್ ಕ್ವೆಶ್ಚನ್ಸ್ ಆಗಿದೆ
ಅಡ್ಮಿಟ್ ಆಗಿದೆ. ಫೈನಲ್ ಹಿಯರಿಂಗ್
ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಆಗಬೇಕು.
ಮೇ ಬಿ ಆಫ್ಟರ್ 3 weeks.
ಆಫ್ಟರ್ 2 weeks ಅಂತ ಹಾಕೊಳ್ಳಿ ನೋಡಿ. Okay.
And 40 also, my lord. It's
40
got
also?
various issues.
Ah.
Has to be after 2 weeks.
All 2 weeks.
My lordship, serial number 37, my lordship. Short
37?
argument. Yes, my lordship.
ಯಾವ್ದಮ್ಮ? 2017 matter.
Yes, my lordship. My senior is out of station. That's
ಕೊಡ್ಬೋದಾ?
ಕೊಡ್ಬೋದು. I don't come in the way. It may not
Reach also.
3 is also passed over.
3 is also passed over. Company application. No, idadakshana mostly, Mr. Naganand will send words. Suppose if we become free, we'll call you. Huh? Okay. Yeah. Yes.
So my lords have seen centum, which my learned friend relied on. How centum has been dealt with by two decisions of learned single judges in Kirloskar and Sonam. Sonam explains what is the scheme of the act, what is the importance of input tax credit, how it needs to be dealt with. Kirloskar says, Justice Kothari's order, that machinery provisions, return filing provisions
Cannot override
substantive provision.
But only whether it should be separately, but that does not refer to Rule 38.
No, they don't.
Refer
Rule 38 has been for the first time invoked by the department in this case. It was not dealt with in centum also.
Consider
Rule 38 has not been considered because, like I said, Rule 38 does not impose a condition that or restriction that if I don't claim it in the return, my claim
should be
is
rejected.
Extinguished. My claim is extinguished. It does not say so. Therefore, Rule 38 was never dealt with. Now, this honorable court, two learned single judges in Kirloskar and Sonam explained the provision, the scope of the provisions, and have said that 10.3 provides for a substantive relief to an SC. Machinery provisions cannot override that. They have dealt with centum also. And Sonam, in fact, says centum has been subsequently diluted by an amendment by inserting a proviso which is more of a benefit.
10.3.
Proviso to 10.3, which is more of a benefit that the state has given. Proviso, like I submitted, does not also impose any restriction on me that if I have not claimed it in the return, I cannot, my claim is effaced. And those two judgments have been affirmed by a division bench of this honorable court in BML. BML also says, my lord, referring to Supreme Court decision in Daiichi, which I cited, that input tax credit, which is equivalent to Senvat credit, is an indefeasible right. That judgment of BML, a division bench of this honorable court, has been affirmed by the Supreme Court, although leaving the question of law open. Now, your lordships have had a doubt as to what is
the law. It means so it's left to the Supreme Court to decide.
That's elaborately dealt with, my lord, referring to, I had on that day referred to Kune Ahmed. And there's also codes which the Supreme Court explains what is, if SLP is dismissed in one line, if it is civil appeal dismissed in one line, what is the impact? Referring to those two judgments of the Supreme Court, Gujarat High Court has said in somewhat similar situation as to what is the impact of the Supreme Court saying that the question of law is left open.
Left open to be considered by the Supreme Court itself.
That's what the Gujarat High Court explains. In
Which
detail.
paragraph?
I have now educated myself. That proposition is not contested by me. It is to be decided by the.
Very elaborate discussion. Just, I mean, I must say, my lord, para 26, my lords kindly, I mean, just for academic interest, since my learned friend has agreed.
Question of law is kept open would only guard against any future contention that the Supreme Court had confirmed the ratio of the judgment, whereby either giving rise to possible contention of merger or so and so. The Supreme Court would be precluded from considering such an issue in bitter facts. First step. Left open to be considered under other meaning, very non meaning baralladu. Otherwise, if it were to be otherwise, that would rob away the presidential value of the High Court judgment.
Precisely.
So as it rightly says,
the High Court judgment has now to be seen for what it actually says.
In the light of all these, my lord, now my lords may kindly see, although I have read this judgment decision earlier, a decision of a division bench of this honorable court in my own case for a previous year.
This is Aradha's.
Yes.
Aradha's judgment you read other day.
I've read. My lords had a doubt whether the question was the same. Is it not a question of limitation? Let me clarify. That was also a case where claim was not made in the return. The department's contention was that since they have not made the claim in the return or file a revised return, they cannot claim it. Justice Aradhe, my lord, noting Kirloskar and Daiichi.
Which paragraph?
Yes. If my lords kindly see the question first. Paragraph, page 3 of TAFE. My lords have TAFE?
Page 3, para 4.
Page 3, para 4.
Holding that the petitioner
Is entitled for claiming input tax credit is eligible to avail the provisions of so-and-so, read with so-and-so, merely because the petitioner had inadvertently understated its input tax liability eligibility in its returns filed for the relevant tax period and has failed to rectify the bona fide error in revised returns filed within the prescribed time. Kindly see the contention of the department also at page 5.
Revised returnal claim ಮಾಡಿದ್ರು no?
ಇಲ್ಲ ಮಾಡಿಲ್ಲ.
ಅಲ್ಲ ಇದರಲ್ಲಿ.
ಅದರಲ್ಲೂ
ಆರಾಧ್ಯ ಸಾಹೇಬ್ರ ಕೇಸ್ನಲ್ಲಿ.
ಮಾಡಿಲ್ಲ.
Kindly see the sent the question.
And has failed to rectify the bona fide error in the revised returns filed.
Even there he had not.
Even there he has not rectified it. Facts ನಲ್ಲಿ ಬಂದಿದೆ. Page 5 ನಲ್ಲಿ ನೋಡಿ. First sentence. The prescribed authority rejected the claim of the petitioner on the ground that the petitioner had not made such claim either in the original returns or
in the revised return.
Now, paragraph 3 nalli, the judgments relied upon by my learned friend were noted. Infinite Builders and Centum.
Whether Rule 38 is referred to in this? You have answered it.
Rule 38 has not been referred to in any of the earlier judgments.
Your one line answer is Rule 38 is a machinery provision. Therefore, it cannot override the substantive provision.
In any case, Rule 38 does not restrict me from claiming.
That's another.
Correct. Infinite and Centum, which my learned friend relied on, are referred to at page 3.
All judgments, including Giridhar Lal Parasmal.
Giridhar Lal Parasmal, and kindly see what the
where it is answered.
Paragraph 8 onwards.
Directly one sentence bani.
Para 10, page 16. In the instant case, the essay had claimed the benefit of input tax credit at the rate of 4%. However, subsequently a claim was made for an additional input tax credit at the rate of 1% on account of an error in disallowing input tax credit at the rate of 4% as specified in section 14 instead of 3% as specified in notification. No time limit has been prescribed under the provisions of the Act for making a claim for additional input tax credit. Therefore,
before 10.3 amendment.
No, even that, like I said, my lord, this is a case of not claiming in the return. The question was whether if I have not claimed it in the return, can I claim it before the assessing authority?
So indefeasible, right?
Therefore, the claim of eligible input tax credit is an indefeasible right, which is available to the dealer under the Act without any limitation of time for claiming such credit. It is pertinent to note that section 14 provides for special rebating scheme where the deduction of input tax shall be allowed on purchase of goods that are dispatched from outside than as a direct result of so-and-so. Kindly see the last sentence, paragraph 1, top paragraph, page 17. Therefore, the petitioner cannot be deprived of the aforesaid statutory benefit, and section 35 of the Act does not curtail the entitlement to such statutory benefit to it if such return is not filed within the time prescribed therein. Then infinite and centum were dealt with in paragraph 11, distinguished. Now kindly see the tribunal's order. The impugned order.
ಇದಕ್ಕೆ ರೆಫರ್ ಮಾಡ್ತಾರೇನು ಅವರು?
ಹೌದು. The tribunal relies on this.
ಏನ್ ಹೇಳ್ತಾರೆ ಅವರು?
That they are directly on facts. Same case, SSC's case, that was earlier assessment year, this subsequent assessment year. Tribunal notes the facts and says this decision is directly applicable to the facts. Which paragraph should I read? Kindly see the impugned order now. Tribunal also has elaborately dealt with all these contentions independently and relied on the decision of this order. Paragraph 40. My lords have the impugned order. The impugned order, my lord, starts at page 18 of the appeal papers of the STRP papers.
18.
18. Then the discussion, my lord. Reasons start from running page 33, internal page 16. I'll not trouble with the facts, trouble your lordships with the facts.
Internal page 15.
Internal page 16, 16. 15 only question, so whether the SMR authority has an error in revising the order, so and so. Because I made the claim before the assing officer. In this case, what happened, my lord, during the course of the 39 proceedings by the assing officer, after the order was passed, I made an application for rectification and the assing authority allowed my claim. Assing authority allowed my claim. A superior authority revised that order. Against that, I filed this appeal. Then kindly see the para 27, the first appellate authority relied on, the revisional authority relied on Nandi and Centum. Nandi Constructions, which is the other decision cited by my learned friend. Then if my lords kindly come to paragraph 40 at running page 43, internal page 26. In fact, paragraph 37 onwards. 37. My lords have that?
Yes.
Running page 43, internal page 26. To sum it goes without saying that statute provides for a period within which the return is to be filed under section 35(1) within 20 days or 15 days after the end of the preceding months. Subsection 4 of section 35 provides for filing of a revised return if the SC discovers any omission or incorrect statement in the returns filed under section 35(1). At the relevant point of time, such a revised return has to be filed within 6 months from the end of the relevant tax period. Therefore, the statute provides for filing of a return claiming input tax rebate within the period prescribed in law. If in the return filed there is any omission or incorrect statement, a provision is made for filing of a revised return within the time prescribed. If the returns are not filed within the set period, then the SC would not be entitled to the benefit of setting off output tax against input tax. In the instant case, it can be gathered from the arguments of the learned counsel and from the records that for the period in question, the appellant had filed the monthly returns of turnover in form VAT 100. Further, inter alia, the appellant, while calculating its net tax liability under the Act, has claimed input tax credit on the purchase of inputs chargeable to VAT at 12.5% on the manufacture of stock transferred goods at a rate higher than 2% with effect from 1/4/2008. And as per the provisions of 11A5 and section 14 of the Act, read with notification number so and so and so and so, and notification issued under the provisions of the CST Act. In other words, the appellant has availed input tax credit to the extent of 10.5% on the local purchases of inputs chargeable to VAT at the rate of 12.5% used in the manufacture of stock transfer goods. However, it was further noticed by the bench that the appellant, in an inadvertent manner and on a bona fide belief that the aforesaid benefit of entitlement to avail input tax credit on goods used as inputs in the manufacture of stock transferred out goods was only available in respect of goods liable to tax at the rate of 12.5% and not available in respect of inputs purchased at the rate of 4% utilized in the manufacture of stock transferred goods, has not claimed the benefit of input tax credit at so and so, that is 4% minus 3% in the monthly return of turnover in form VAT 100 filed for the tax periods April 08 to and May 08. Also, the appellant has not claimed the benefit of input tax credit at 2% in the monthly return of the turnover in VAT 100 filed for the tax period June 2008 to March 2009. In other words, the appellant for the period from April 2008 to May 2008 has not availed the input tax credit to the extent of 1% on the local purchase of inputs to VAT at the rate of 4% used in the manufacture of stock transfer good. Also, in other words, The appellant for the period June 2008 to March 2009 has not availed input tax credit to the extent of 2% on the local purchases of inputs chargeable to tax at the rate of 4%. It can very well be seen, that the appellant was unaware of the above mistake committed inadvertently by him, and on the pretext that there were no mistakes committed by him in filing the original monthly return of turnover in form VAT 100 for the periods in question, has not filed revised returns for the aforesaid periods in question. At this juncture, the bench would like to infer upon the facts that when an assessment under 38(1) is disturbed.
Kindly come to page, internal page 38, page 55,
Yes.
running page 55.
Yes. It can be
inferred from the above deliberations.
From the above deliberation that the provisions of the Act has not prescribed any time limit for making a claim for additional input tax credit as per the provisions of Section 14. Therefore, it can be deduced from the above discussions that the claim for eligible input tax credit is an indefeasible right which is available to the dealer registered under the Act without any limitation for claiming such input tax credit. At this point of discussion, it becomes relevant and appropriate to note Section 14 provides for special rebating scheme whether the deduction of input tax shall be allowed on purchase of goods that are dispatched outside the state other than direct result of sale and purchase made.
Now come to 69.
Yes.
That is para 69, page 56.
Yes.
From 65 itself we can read.
Yes.
Under
these circumstances, firstly, the appellant cannot be deprived of a aforesaid statutory benefit, and secondly, the provisions of Section 35 of the Act does not curtail the entitlement of the dealer to such statutory benefit, even though such return is not filed by the appellant within the time prescribed therein. In the light of the above discussions, the order of the AA in extending the special rebating scheme to the appellant as per the provisions of Section 14 of the Act is found to be correct and proper and is as per law, and hence the appeal needs to be allowed. In the light of the above rectification order, so and so needs to be upheld. Consequently, the appellant for the assessment period so and so is eligible, and they are eligible from June to March also, therefore for the so and so. And 53, my lord, is the reference to the earlier decision of this honorable court in TAFE.
Okay. Yes.
Para 53.
Yes, I have read entire order.
Then, my lord, just supplement, I had cited 3 judgments, Giridharlal Parasmal and Justice Ravindran's and Justice Kumar's in Wipro on if I don't make a claim in the return, can I not claim it later before the assessing authority or the appellate authority? There's a Supreme Court also, my lord, which is a case of refund.
Under the same act?
Not this act.
IT Act, no?
But a sales tax act. There what happened, my lord, the tax was paid at a higher rate.
In other words, what you say is power to levy tax has to be legally justified. You cannot tax me twice. That is how substantive provisions have been structured in the Act. Whatever manner, form, etc. are only the machinery provisions. They cannot silence your indefeasible right to have the refund.
Once it is granted, my learned friend's contention is input tax credit is a concession and all that. But like I submitted on the first day, once that concession is given
by the act,
then it becomes a right, an indefeasible right. Merely because I have not claimed it. If the Act itself specified some restriction saying that if you have not claimed it in the return, your right is extinguished, which power I'm not saying that the legislature does not have the power to,
but that has not made it.
That is not made. And that is what all these judgments say, that there is no restriction for claiming this input tax credit merely because you have not claimed it in the return. This a couple of paragraphs in this Supreme Court judgment.
Otherwise, double tax.
Double tax, more than double tax, tax that I have already paid in advance. You don't want to give me credit.
That amounts to double tax.
Virtually, yes.
You are taxing it again. That is not supported by the inner voice of the legislation.
That's it. If in this judgment, my lords, if my lords kindly turn to this was a case, my lord, where Initially, the tax was 1%. Subsequently, the government reduced the tax rate from 1% to 5%, but the SSE filed the returns as if it was 1%. Then later claimed a refund for the 0.5%, realizing that the tax was at a reduced rate. Refund was initially the learned single judge said, you go before the authorities, I will not interfere. Division bench reversed the learned single judge's order. Supreme Court says, kindly see what the Supreme Court says. Paragraph 19 of this judgment.
There is an army of youngsters coming that side. They are not coming the your side at all, Mr. Aditya. Why? So the battery of lawyers are coming this side to assist the learned counsel appearing for the assessing, not the King's Counsel.
There is a instance in the Mahabharata. Arjuna goes and stands
At the feet of Lord.
at the feet of Lord Krishna, and Duryodhana is given the entire Narayani Sena. Your lordships used the expression army. I was reminded of that.
Yes.
Paragraph 19.
Not mention it. Oh, Krishna told him, oh Duryodhana, you have everything and you are knowledgeable also. Why you are treading a wrong path? Why you should not quit that path and come to the right path? Very beautifully in Sanskrit, he answers in Mahabharata, Duryodhana answers Lord Krishna. Krishna, janati dharmam nakame pravruttyaha, janati adharmam nakame nivruttyaha. Krishna, I know what is the righteous path, but I am not in a position to tread on it. I know that the path I am treading is a bad path, but I am not in a position to tread it because I am immensely addicted to it. Duryodhana's answer, many times it happens to all people also.
And Duryodhana, because he stuck steadfastly on the path that he believed in, was granted Swarga. So when Pandavas go after the walk in they perish in the
All
Himalayas.
they go to Swarga.
Yeah, they then find that Duryodhana is there.
Correct.
They are astounded and they're told that he followed what he believed in.
He
to
believed.
the hilt.
There was no dichotomy in
There
him.
was no dichotomy.
He practiced what he believed. Therefore, deserves a place in Swarga. Yes. So this is how their 0.5% was permitted to be refunded.
The excess paid, although it was not rightly claimed in the return. The excess claim, this is what the Supreme Court says, paragraph 19, your lordships may see. Article 265 of the Constitution of India mandates that no tax shall be levied or collected except by 19, my lord, 19.
265.
Article 265
no
mandates that no tax shall be levied or collected except by authority of law. In terms of the said provision, therefore, all acts relating to the imposition of tax providing inter alia for the point at which the tax is to be collected, the rate of tax as also its recovery must be carried out strictly in accordance with law. If the substantive provision of a statute provides for refund, the state ordinarily by a subordinate legislation could not have laid down that the tax paid, even by mistake, would not be refunded. If a tax has been paid in excess of the tax specified, save and except all the cases involving the principles of unjust enrichment, excess tax realized must be refunded. The state, furthermore, is bound to act reasonably having regard to the equality clause contained in Article 14 of the Constitution of India. It is not even a case that where the doctrine of unjust enrichment, I'll skip that, kindly come to paragraph 24. The statute, furthermore, it is right, should be read in a manner so as to do justice to the parties. If it is to be held without there being any statutory provision that those who have deposited the amount in time would be put to a disadvantageous position and those who were defaulters would be better placed, the same would give rise to an absurdity. Construction of the statute which leads to confusion must be avoided.
Precisely my case. Precisely my case.
How is it?
Defaulters cannot be rewarded.
Default of tax, default of
To put him in that.
default person was not paid tax is a defaulter, not me who has paid in excess and saying, please don't retain it.
Defaulter means who has not complied with the prescribed form ಅಂತ ಅವ್ರು ಹೇಳೋದು.
That's how he has understood it.
Anyway, all. So it should be even. That's the point.
That's the point. And my lord, the decision cited by my learned friend to say that input tax credit is just a concession. Like I
No,
pointed out,
that is a.
those are all cases where constitutional validity of provisions imposing restriction on claiming input tax credit or SUNVAT credit, whatever the case may be, were challenged.
No, where statute gives that right, you can't say that it's a concession.
Correct.
The
Once-
apex court which Aditya read the other day, it was in a different context
Context.
where virus was put in challenge.
Correct. That they
That's the
said that the
reason.
state could not have done it because it's violative of Article 14, 19(1)(g) and all that contentions were taken, which the
Input tax concession does not make it any more the concession or any less the right once it is enacted.
correct.
Is
And
your
in this
subject.
case, my lords may kindly note, they don't say that I am legally not entitled for this input tax credit otherwise. That is not the case of the department.
They say you have not claimed
Claimed it in the return.
in the return.
My right to claim the input tax credit is admitted or undisputed.
Your
Only
procedure,
because I
procedure
made
you
the,
have not followed.
only because I have not followed the procedure, they say you are not entitled.
Whether this question did not figure in that Mafatla?
No, Mafatlal was a case, if your lordships recall, 9-judge bench.
You have that judgment, Mafatla,
have-
passed
I have
it on.
My lords, what?
Just see one paragraph. Vaguely I remember.
Mafatlal was a
Mafatlal
case,
case.
my lord, where refunds, some people, my lord, in another SSC's case, if a provision is held to be ultra vires, can the SSCs who have not challenged it,
Can they claim?
can they claim
That
it?
was on the ground that doctrine against unjust enrichment. Because already.
Unjust enrichment, all those
Will consider.
doctrines were discussed. And they said, if you have not made the claim in the form prescribed under the provision of the act and all that, you have lost the right to claim it subsequently just because another person's case, it has been held to be the correction of the tax to be not correct. It was in that context, my lord.
Paragraph, I vaguely remember, I think Mafatlal is 97 or 98,
97.
97.
But what happens is,
Yes.
Justice Jeevan Reddy retired, writing for the majority, says that the claim for refund can only be in the manner provided by the statute. That is the view of the majority. Justice Ahmadi concurs with the majority judgment, except to say.
Five
that-
judge it is.
Five judge.
9.
Nine judge.
Nine judge. Except to say that everything else is correct, but here I may leave provision for suit or writ also. So the context in which.
Out of 9,
My lords,
how many say? How, suppose there are only 2 judgments. It appears 2 judgments, 3 judgments.
there are
Three,
three,
my lord.
three judgments. my lord.
Justice Reddy, Justice Paripurnan, and Justice Ahmadi wrote separate.
I think Sen is dissenting.
Sen, Justice Sen is also there.
Sen is dissenting.
No, dissenting is single loan wise.
Three,
Therefore, it does not make any
three
difference.
concurring judgments.
3 concurring judgments.
Yes. Verma, Agarwal, Jeevan Reddy, Anand and Kirpal.
On which question concurring? Because when a bench comprising of plural judgments writes plural judgments,
Therefore,
how ratio decidendi has to be worked out?
therefore, this editor's note,
Ah.
very conveniently, the SCC has given a editor's note. If my lords kindly see the first page. That
Of
of what my learned friend just passed on. Mafatlal.
Wafatla. Who is the editor? What is his credential?
SCC, I mean, it's a journal.
No, that we cannot go.
Correct.
Generally,
No,
the editor
to sum
cannot
up.
lay down the law.
To sum up,
He can sum up,
Correct.
but we have to see the law itself,
correct.
not a editorial
No,
note.
but to see what were the questions for consideration, just to understand what fell for consideration before the 9-judge bench. The claims for refund, I'll just read the editor's note, my lord, unless my lords want me to read.
Very well. No, just wanted to know,
Yeah.
what are the credentials of editor? Is he a man of law?
No,
Suppose
I'm not
SCC.
sure. I'm not sure.
SCC, Surendra Malik. He is a Columbia University master's degree, doctorate also perhaps, gold medalist.
His son Sumit Malik was with me in National Law School. He also went to Columbia, I feel.
Columbia University. If such writers write something, then we can read their version. This is SCC only.
Yes, yes.
SCC. Not some substandard
No.
editor or lawyer writing, we don't read at all.
Lordships may take para 77
77
at page 605. Before that, my lords may kindly take 32 where the contention is recorded. Para 32 at page 580.
Five
580 minutes.
Just amount involved agide case nalli. More than amount is a law.
It's a law. Same question keeps coming.
No, whether this, if it is decided, just we want to know. Because if suppose if we hold that there is no prescribed limitation period, not there is any prescribed form for claiming benefit of input tax,
Chaos.
concession, whether it will open up floodgates of litigations or it will be
No,
confined to.
according to me, Centum has opened. That's what the
That the gates are
other
already
benches
open.
of the High Court have said. The clouded understanding or interpretation of the revenue basis Centum has led to all this chaos. In fact, Centum has led to all these litigation. Like I pointed out on the first day itself, no other state has this issue of denying me the input tax credit if I have not claimed it in the return. No other state. And my lords may kindly see Centum appeal admitted before the Supreme Court, infinite appeal admitted before the Supreme Court. The orders in our favor, SSC's favors, SLP has been dismissed.
Leaving the question of law open.
Leaving the question of law open, no doubt about it. I'm not.
The codes explains how dismissal of SLP is to be read. The first gate is whether SLP to be admitted, not admitted. For whatever reason, I choose to refuse to exercise my discretion. Therefore, there is.
It does not become law declared by the Supreme Court.
It does not become law declared by the Supreme Court unless the Supreme Court actually declares it even at the stage of rejection. Then, as your lordship said in the morning, 141 follows an imperator of the Constitution. It's not precedential. In this case, not only, and he says, even if I say I am dismissing it on merits, it does not constitute law laid down unless law is specifically declared.
I'm not saying that it is law laid down, but the coordinate bench
seal of that.
Seal of the Supreme Court, the proposition that 10.3 is a substantive provision, return filing and all that are machinery provisions. Machinery provisions cannot override the substantive provision, which is what in substance has been held by Kirloskar, Sonal.
We have heard that one. Let us wait. What is your point? He has advanced about 3-4 points.
Yes.
Number one, tax by authority of law. This is what the Constitution says.
Yes.
If I have already paid the tax.
Yes.
And I forget to mention about it.
Yes.
You cannot withhold on the ground that there is mistake of fact or mistake of law. Because in English law, whatever payment you make in ignorance of law, you cannot get back because ignorance of law cannot have the premium. But under Mafat law,
72 is considered.
72 of Contract Act is considered, where ignorance of law or ignorance of fact. If I make payment, I'm entitled to refund. So this is first proposition. Number two, your rule 38 cannot silence my right, my indefeasible right to use these words. To get it back, Putwal, please be seated. Yes. To get my money back, you cannot ask me to pay tax again and again and again. I have paid, I am an honest man. This is number two. Number three, assuming that 38 requires that he should make that claim in the form itself, 100, something like that. It is only directive. More particularly because my assessment proceedings were not concluded, the same having been reopened and not concluded till appeal is exhausted at least at the level of the tribunal. This is how he is. Lastly, the substantive provisions which give me the right, they cannot be silenced by the machinery provisions. This is how he has structured, and he has cited the decisions in support of that. Which one, first one, first proposition, which one you want to take?
Lords, I would take your lordships back to the act for about 2 minutes.
You can give a thumbnail description of these provisions. We'll read, no issue. We'll read together only.
Before going to the provisions, my lord, I would request your lordships to take the statement of objects and reasons, which were read to some extent by my learned friend. Objects and reasons.
Objections.
Not in the statute. Statement of objects and reasons.
Statement of objects and I thought objection statement.
My apologies. My apologies.
But one of the objects he had shown.
Yes.
The input tax concession refund also.
Absolutely.
Third object of the act or something like that.
Yes.
I remember. Section.
Statement of objects and reasons, my lord. In my book, it is at page 7.
I want to ask one question to you. Whether statement of objects and reasons are voted in the parliament, in the state legislature? What is our procedure? In England, they are not. With that famous author, Erskine May, on parliamentary practice, he says, statement and of object, statement of objectives are not voted in English parliament at the Baritanam. What is our procedure? Are they voted in the legislature? Are they
not to my knowledge? But the marginates are voted. The nomenclature of the section is voted.
Of course, heading and etc., including title to the act.
The statement of objects and reasons was invoked by my learned friend to impress upon the court the objective of the act and what in substance is the pith of the act. 3, 4 and 5 were read. Your lordship may kindly take 7. Roman 7.
Promotes
voluntary compliance
by providing
for acceptance of returns filed by dealers on self-assessment basis and for scrutiny of books and account only in selected cases. The whole scheme, my lords, and your lordships will see 38, section 38, before I go to rule 38. Having seen this, my lords, lordships may kindly take section 10.
Yes. Output tax, input tax, net tax.
Yes. He is required to, under 3, my lords.
Subject to input tax restriction.
Specified in 11, 12, 14, 17 and 18.
19.
19. The net tax payable by a registered dealer in respect of each tax period shall be the amount of output tax payable by him in that period, less the input tax deductible by him as may be prescribed in that period, and shall be accounted for in accordance with the provisions of the Act. The accounting is a must.
Please read again.
My lords. Subject to input tax restrictions specified in 11, 12, 14, 17, 18, and 19, net tax payable by a registered dealer in respect of each tax period shall be the amount of output tax payable by him in that period,
Minus input tax.
less the input tax deductible as may be prescribed in that period, and shall be accounted for in accordance with the provisions of the Act.
Shall be accounted for andre.
He, in accordance with the provisions of the Act, he needs to prepare a statement as required by the Act.
So this is the net tax payable.
Yes. Now this has to be calculated and shown somewhere.
Yes.
And this is subsection 5 also,
Yeah.
while my lords are in that section.
Subject to input tax restrictions specified in section 12(8)(19), where under subsection 3, the input tax deductible by a dealer exceeds the output tax payable.
Correct.
The excess amount shall be adjusted or refunded together with interest as may be prescribed. In input tax amount total, if it exceeds the
Therefore,
output
I am
tax,
saying, what is the,
then
why
that
I
should
am
be
saying it is an
refunded.
indefeasible right? It has to be refunded to me because it's a tax already paid by me.
provided you file the return.
Provided you file that.
It doesn't provision, this provision doesn't say so. This
No.
provision doesn't say.
No, you can't read one per subsection
Correct.
as an island section.
Correct. Which other provision under this section, subsection, under this section says that unless I file the return, I cannot.
No, you mean to say how they will know?
Therefore, I made the claim before the assessing officer.
No, question is not that. You want to say, because right from 1870 at least, the Privy Council said, how you are going to construct the act? Read whole of the act.
Correct.
Then come to the chapter. Read every section in the chapter. Then come to the section. Read every subsection in the section. Then come to the proviso. Read every part of the proviso.
Correct.
Now we have been taught in law school.
Correct. That's the right way of.
You can't read subsection 5 divorcing the requirement of your filing a return.
No, that return filing is not in 10. Return filing is in 35, my lord.
That is true.
Correct.
That is true. This cannot operate in the absence of you filing the return at all. You mean to say, even when you do not file any return, you are
If
entitled
I
to
have filed the return in this case.
No, that's unfair. We are not on.
If I don't file the return,
purely on question of
that was
law.
exactly the case, my lord, of infinite builders where no return was filed. This is not a case of no return. Return was filed.
It was not accepted.
Input
Therefore,
tax.
revised returns case.
No, this is a case where return was filed. Input tax credit was also claimed on 12.5% purchases that I have made. On 4% purchases I have made.
Rate is the question.
Rate is the question. That differential 1 or 2%, by my misunderstanding of section 14, I did not claim it in the return. I claimed it subsequently before the assessing officer who granted it to me in the first instance. I am not saying that if I don't file the return,
they have made a claim in the return.
They have not. Some claim is made and that they have given credit for. Right, let me say, I think TAFE.
Two cases. Is it a case of absence of the input tax concession kept blank?
No, no,
It is not.
it's not.
These claim, but rate of
No,
tax.
no, my lords, respectfully. I think they manufacture tractors and cars, etc. This Skoda dealership ide, matte the tractors also they manufacture. So let us say they are procuring some resin, which is not prohibited as an item under 11. They may have procured XYZ, which is for which they have paid input tax. For their selling dealer, it is output tax. Credit has been claimed in the return. They have received credit. When it comes to section 11, there is a prohibition that with respect to the following items, no input tax credit shall be claimed. 14 carves out a limited exception to the prohibition. So this theory of indefeasible right, vested right, etc. is still born because it is a limited exception to a prohibition. The governing rule is in 11, which is a prohibition. No input tax credit.
Unless he shows that he fits into exception.
It fits within the exception 5 and 6 to the limited extent of the difference in.
All right. Once he fits into exception.
Yes, he should
even
claim
then
it.
you mean to say it's a concession?
It's a concession.
Right, will not right arise when he fits into it. If he demonstrates that I fit into this exceptional clause, still
he has to comply with the manner in which it is to be claimed. That's the short case. Now, your lordship saw the language in 10.3 shall be accounted for in accordance with the provisions of the Act. Your lordships may kindly come to 35. I'm reading, just to labor the point, I'm reading 10.3 again. Subject to input tax restrictions specified in 11, 12, 14, 17, 18, 19, net tax payable by a registered dealer in respect of each tax period. Now your lordship may come to 35.
returns.
Yes. My submission in 10 was, when he says accounted and shall be accounted for, that is the return.
No, that is not the return. That is section 31 accounts. There's a provision which deals with accounts.
We'll come to 35.
That is my books of accounts.
Subject to subsections 2 to 4, every registered dealer and the central government, state government, statutory body and a local authority liable to pay tax collected under subsection 2 of section 9 shall furnish a return in such form and manner, including electronic methods, and shall pay the tax due on such return. The liability to pay tax, my lords, which is dealt with in 10.3, which is net tax equal to
output tax
minus input tax. 35 says that you will pay the tax which is calculated in this return within 20 days. Now your lordships may come to 35.4. I also have a copy of how 35.4 used to stand at
pre-amendment.
It is not that relevant, but there is a minor change. I have got the book itself. It is extracted in centum, so that it's not as if there is something revolutionary.
No, law you can read.
Yes, ma'am.
Law need not be proved.
Yeah.
Facts need to be proved.
My lords.
Of course, in one judgment, the Attorney General was examined to show whether Magna Carta is law or not. Under section 5 of the Evidence Act, section 5 says, evidence can be led to prove facts in issue or facts relevant to the facts in issue and nothing else. You can't lead evidence to prove the law. Exception is only
Foreign law.
Custom. Custom is source of law. So custom, for that you have to prove that's the only exception.
In India, foreign law
is treated as a fact. Therefore, evidence is permitted.
Subsection 4, my lords, your lordships have the
35(4). If any dealer
having furnished a return under this act, other than the return furnished under subsection 3 of 38, discovers any omission or incorrect statement therein, other than as a result of an inspection or receipt or any other information or evidence by the prescribed authority, he shall furnish a revised return within 6 months from the end of the relevant tax period, except when such revised return.
Pre-amendment. That within 6 months has gone.
No, man, it is there. In the lordships may now see the amended. B.
He shall furnish a revised return anytime thereafter, but within 6 months from the end of the relevant tax period, if so permitted. So you mean to say there is a period of limitation, then there is a prescription of the formats, which all should contain.
Yes.
This one.
Yes.
And accounted for is your stress.
Accounted for, and the tax payable under 35 is on the return. 10 tells me how the tax is arrived at. 35 says pay the tax on the return. It is inescapable. The importance of the return is inescapable.
So, in other words, 10, 4 or 5 which he read, it cannot operate without filing a return at all, obviously. Let us read that provision again, which Surnarayana read. 5. Subject to input tax restrictions specified in 11, 12, 14, 17, 18, 19, where under subsection 3, the input tax deductible by a dealer exceeds the output tax payable by him. All this will be known only when that return is filed, not otherwise at all.
See, what may happen, my lords, is either because of fluctuation of, because of difference in rates, or because there is some benefit that is entitled to, tax is paid, and the output tax is not there. He may not have sold it. So he's entitled to refund. But that calculation can only emerge from the return. Especially when 35 says 35 with which 38 is married, because form and manner prescribed is 38. 35 says he shall pay the tax on the return. How the obligation to pay tax is treated as a machinery provision, I ask myself the question.
Shall pay tax due on such a return.
Yes, on such return. Precisely. Within 15 days.
If I have computed, how it has to be understood is, if I have computed a tax liability as per the return, that tax has to be paid. You cannot, that's all it says. There is nothing
Correct.
that
Correct.
comes out of it.
Correct.
Yes.
And which is not disputed in this case, that I have not paid the tax.
That's
right. Because if I don't pay the tax, my lord, they have, there are provisions to levy penalty, interest, various things are there.
Yes. Yes, Mr. Aditya.
Now, your lordships may take 38, section 38, before I go to rule 38.
Assessment of tax.
Yes.
Idu vanishing inka? What of permanently ಉಳಿತಾ? ನಾವು vanishing ink ಕೊಡಬೇಕು. Suppose ನಮ್ಗೆ ಬೇಕಾಗ್ತದೆ ನಾವು ಮಾಡ್ತೇವೆ, ಆಮೇಲೆ ಮತ್ತದು ಹೋಗ್ಲೇದ್ರೆ ಮಾಡ್ಬೇಕು.
ಅದು
yes.
Court fees ಬದಲು the litigant should be asked to provide the High Court library of all the statutes.
Yes. You have to provide
all the statutes
judges who read also. Yes. Every dealer shall
be deemed to have assessed to tax based on the return filed by him under section 35, except in cases where the commissioner may notify the dealer of any requirement of a production of accounts before prescribed authority in support of a return filed for any period, and such authority shall proceed to assess such dealer on the basis of the return where he is satisfied that the return is correct and complete.
It's a self-assessment.
Self-assessment. The return is the assessment.
Unless he disagrees with that. Yes. Is it conclusion of assessment? Unless reopen.
Unless 39, my lords. Now I'm coming to 39.
Reassessment.
Reassessment. The reason this is called reassessment is the return is the assessment, deemed assessment.
Deemed assessment. I think deemed, it uses the word deemed also.
Yes.
Shall be deemed to have been assessed.
Based on the return.
Unless case travels to 39.
Yes.
In this case, it traveled.
In this case, it traveled. Indeed. Kindly see what 39 says. Where prescribed authority has grounds to believe that any return furnished which is deemed as assessed or any assessment issued under 38 understates the correct tax liability of the dealer, may, based on information available, reassess to the best judgment additional tax payable and shall issue a notice. Then it says whether there is any further evidence. Prescribed authority has reason to believe that the whole or part, any part of the turnover dealer in respect of any tax period has escaped reassessment, or tax has been underassessed, or which has been reassessed at a lower rate, any deductions or exemptions have been wrongly allowed in respect thereof. The prescribed authority may, notwithstanding the whole or part of the escaped turnover was already before the said authority at the time, proceed to make any further reassessments.
Why he does not say any deduction or exemptions have been wrongly denied?
Precisely, my lords. There is a circular also that addresses it. I will come to it.
You mean to say legislature has consciously said like this?
Consciously.
That means legislature wants to retain money of the citizen wrongly paid.
The legislature will reward people who are the executive is empowered by the legislature to reward the compliant. Those who are non-compliant, I will hold it in public trust for the benefit of the larger public as opposed to a single assessee. I am not, I'm
state.
I'm state. I hold it in trust for the
So
larger
we can't say that it is like appropriation or misappropriation also.
Precisely. Now my lords may come to.
Because that money will enter the state coffer, which will hold in trust for rest of the people, for all people, including himself. So great answer. If it were to be private persons, many other such things would have. But here is the state acts as the parent patria.
Absolutely. Absolutely.
No, but until a claim is made.
Anyway, his version.
No, I'm saying, even Mafatlal says, until a claim, even in a case of unjust enrichment, the person from whom I have collected the tax has the right to go to the government and say, this is my money, give it back, and the state cannot withhold it.
Correct.
Holding in public is money which I have unjustly collected. Or
and you are retaining others' money.
Others' money. This is my money. You cannot retain my money. If a rightful claim is made, the state, that is why 265 is there.
No, his answer is, I have understood your point. You have made it a point also. His answer to my assumed legislative defect, he says it's not a legislative defect. It's the policy of the state that if somebody does not follow a particular procedure to get back whatever is due to him, arguably, that would the state, you cannot say state is retaining it unjustifiably, because state is the parent of the people under the doctrine of parens patria. Therefore, it will be used for all the people. Don't say that the very idea of doctrine of unjust enrichment is quasi-citizen. It is not quasi-state at all. Even in Mafatlal. Mafatlal refers to Australian writers, jurists. The unjust enrichment is, you are taking money from the public, You want to retain on the ground that you need not have passed it on to them. But already you have received.
You have collected it.
Collected it. You can't say wrongly you have collected, pay it to me. Because you have taken it from others.
Correct.
At the most,
Only-
others may seek a claim.
Only in
not
such
you.
a case, can the state have the right to retain that money? If, not in other cases.
That's right. Yes.
Now your lordships may come to rule 38. The formula for tax is given in 10. The obligation to demonstrate in a return input minus output is given in 35 and elaborated in 38.
Is simple illa. Yes. 38.
Every registered dealer shall submit a monthly or quarterly return.
It
as-
is you have to read it with 38, section 38 only.
Section
35 only.
35.
35. Okay.
35. And primacy of return in 38 and 39 also I have shown. The deemed assessment is the return. Reassessment is based on the return. If even if they are conducting an assessment under 38, it is based on the return. And 38.
So return is the basis for all activities under the Act.
Yes, yes, yes.
Okay.
Every registered dealer shall submit a monthly or quarterly return as the case may be, containing values of sales, purchases and other transactions, input and output tax claimed or collected and net tax relating to all of his places of business, and accompanied by proof of full payment of any tax due, including any certificate of deduction at tax and a statement containing the details of purchases made within the state from other registered dealers in respect of which he is eligible to claim deduction, and sale of taxable goods made to other registered dealers to the local VAT officer in Form 100 within 20 days.
Yes.
This calculation or computation flows directly from 10, my lords. It is not dehorse 10 at all.
Input and output tax claimed, collected, and net tax relating to all of his places of business, so and so, so and so.
Nothing other than the working of 10.
Leonard Fund is citing judgments in reply. I should be given opportunity to rebut.
I will not haste because very, very consequential judgment agatti. We will not haste. So we are not in the middle, we are disturbing you. We are interfering with his questions also. ನಾವು ಆ ರೀತಿ ನಿಮ್ದು ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಯ್ತು ಅವ್ರ ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಯ್ತು ನಾವು ಹಂಗ್ ಮಾಡಕ್ ಬರಲ್ಲ ಇದೆಲ್ಲ ಇದಕ್ಕೆಲ್ಲ ಲಾಟ್ ಆಫ್ ಡಿಸ್ಕಷನ್
Citing it in reply.
ಒಂದು
Leonard
ಡಿಸ್ಕಷನ್ ಆಗ್ಬೇಕಾಗ್ತದೆ ಹೊಸ ಹೊಸ ಪಾಯಿಂಟ್ ಇರ್ತದೆ ಅವಾಗ ಯು ಹ್ಯಾವ್ ಆಲ್ರೆಡಿ ಮೇಡ್ ದೇರ್ ಇಸ್ ನೋ ರಿಪ್ಲೈ ಟು ರಿಪ್ಲೈ ಹಿಂಗೆಲ್ಲ ಹೇಳಕ್ಕಾಗಲ್ಲ. These are all very significant matters. Yes.
Lordships may kindly take
Godrej.
Godrej and Boyce, Lord. Lordships may kindly come to para 3. The appellant or registered dealer under the Act is engaged in the manufacture of various products such as chocolate, drinking chocolate, etc., etc. During the assessment years concerned herein, it purchased raw material, packing material and containers both within the state of Maharashtra as well as outside. In respect to the raw material, packing material purchased from registered dealers, the appellant paid purchase tax to them. Insofar as raw material, etc., was purchased from unregistered dealers, the appellant was liable to and did pay the purchase tax directly to the government. the goods manufactured by the appellant are liable to sales tax when sold within the state. In exercise of rule-making power conferred by Section 74 of the Act, rules have been made by the Government of Bombay. We are concerned in this case with only two rules, 41 and 41 capital A. The purport of both the rules, insofar as is relevant for the purposes of these appeals is concerned, is practically the same, notwithstanding a good amount of phraseological difference between them. Rule 41 applies in respect to purchases made by a manufacturing dealer like the appellant up to July 15, 1962. From that date onwards, it is Rule 41(8) that operates. In respect of their assessment for the period so-and-so to so-and-so, the appellant claimed set off under Rule 41, whereas for the period January 1, 1962 to January 31, 1962, he claimed it under 41(A). Your Lordship will now come to paragraph 6. A reading of. A reading of the rules manifests the intention of the rule-making authority. It is to provide relief to the dealers that ultimately the benefit should percolate to the consumer public. A manufacturing dealer like the appellant pays purchase tax when he purchases raw material, and is again obliged to pay sales tax when he sells the good manufactured by him out of the said raw material. Tax on both the transaction has the inevitable effect of increasing the price to the consumers, besides adversely affecting the trade. It is for this reason that the aforesaid rules enable the manufacturing dealer to claim set-off of the tax paid by him on the purchase of raw materials from out of the tax payable by him on the sale of good manufacturing from out of the said raw material. These rules further provides, and it is that aspect which is relevant in these appeals, that in respect of manufactured goods dispatched by the manufacturing dealer to his own place of business or to his agent outside the state and actually sold there, the amount of set-off shall be reduced by 1% of the sale price of the goods so dispatched. This is the result flowing from a combined reading of clause E of Rule 41, read with the explanation and the proviso appended to the explanation. Same is the position flowing from the relevant provisions of 41A. Now your Lordships may come to 9. Some famous name is there. She so-and-so appearing for the appellants reiterated the contentions urged before the High Court. He submitted that the deduction of 1% in effect amounts to taxing the raw material purchased outside the state or to taxing the sale of finished goods effected outside the state of Maharashtra. We cannot agree. Indeed, the whole issue can be put in simpler terms. The appellant manufacturing dealer purchases his raw material both within the state of Maharashtra and outside the state. Insofar as the purchases made outside the state of Maharashtra are concerned, tax thereon is paid to other states. State of Maharashtra gets only tax in respect of purchases made by the appellant within the state. So far as sales tax leviable on the sale of goods manufactured by the appellant is concerned, state of Maharashtra can levy and collect tax only in respect to sales effected within. It cannot levy or collect sales tax in respect of which are goods that are dispatched by the appellant. In law, the appellant has no legal right to claim set-off of the purchase tax paid by him on his purchases within the state from outside the sales tax payable by him on the sale of goods manufactured by him. It is only by virtue of these rules, which as stated above are conceived mainly in the interest of the public, that he is entitled to such set-off. It is really a concession and an indulgence. More particularly, where the manufactured goods are not sold within the state of Maharashtra, but are dispatched to out-of-state branches and agents and sold there, no sales tax can be or is levied in the state of Maharashtra. State of Maharashtra gets nothing in respect of such sales effected outside the state. In respect of such sales, the rule-making authority could well have denied the benefit of set-off, but it chose to be generous and has extended the set benefit to such out-of-states as well. Subject, however, to the deduction of 1% of the sale price of goods sent out of the state and sold there. We fail to understand how a valid grievance can be made in respect of such deduction when the very extension of the benefit of set-off is only a boon or a concession. It was open for the rule-making authority to provide for a small abridgment or curtailment when extending a concession. Viewed from this angle, the argument that providing for such deduction amounts to levy of tax either on purchases of raw material effected from outside the state or sale of manufactured goods affected outside the state appears to be besides the point and is unacceptable. So is the argument about apportioning the sale price, so and so. So therefore, my lords, in this case, 11 contains a prohibition on input tax.
Only exception gives the refund.
Yes.
Accounting.
Yes. The next judgment, my lords, will make a lot of things much clearer. Justice Lakshmanan's judgment. there is some adjective language that is used in the tribunal's order. Bona fide, out of error, inadvertent. What inquiry the tribunal conducts to come to that conclusion, I am at a loss.
Yes.
Your Lordship may come straight away to paragraph 12. We have carefully considered the elaborate submissions made by the learned senior counsel. It is contended on behalf of the appellant that in respect of interstate sales transactions, the appellant had collected 279 original C forms and duplicates, and that the appellant had separated original C forms for submitting the same to the assessing officer and kept the duplicates separately. Entire file containing the originals and thereafter has been misplaced, and therefore the appellant could only file the duplicates. It is submitted under 12.2 of the Central Sales Tax Registration and Turnover Rules. In case of loss of C forms, if he complies with the above rule, the appellant will be eligible for concessional rate of sales tax. It is stated that when the appellant has complied with the said rule, there is no reason for denial of the concessional rate. The impugned order passed by the respondent was therefore erroneous and is set aside, restoring the order of the assessing authority. In our opinion, the said contention is not tenable and has no force. We have already extracted Rule 6B2 of the Central Trade Sales Tax Karnataka rules and Rule 12.2 and 12.3 of the Central Sales Tax Registration and Turnover rules. In our view, the rule has to be strictly construed. Admittedly, the appellant had not complied with the provisions and therefore he is not entitled to the concessional rate of tax under 8 of the Central Sales Tax Act. Section 8.4 specifically provides that the concession shall not apply to any goods. Then your lordships may come to para 14. Read 13 also. I'll read 13 also. In fact, I'll continue. Section 8.4 specifically provides that the provisions of 1 shall not apply to any sale in the course under the dealer selling the goods furnishes to the prescribed authority in the prescribed manner.
Where you are reading?
My apologies, my lord. I have gone back to 12. I thought there will be better continuity.
Because the further sentence you left, I was just in that 12.
Yes.
Section 8.4A also provides, see, section 8.4 specifically provides that the provision of sub-rule 1 shall not apply to any sale in the course of interstate trade or commerce unless the dealer selling the goods furnishes to the prescribed authority in the prescribed manner.
That I wanted to come back to that. In the prescribed manner. (8.4)A also provides that a declaration be duly filled and signed by the registered dealer, to whom the
last 3 lines.
On the above provision, a registered dealer will not be entitled to concessional rate of tax in respect of interstate sales made by him without the production of declaration referred to under clause A of subsection 4 noted above. Then 13 becomes relevant.
Compliance with the prescription is a must, appears to be the view of in this case.
Yes.
Because section 8 itself says that you have to file it.
Yes, because section 8 required that.
Yes.
Which is parimateria here to section 8? Rule 38.
35 read with 10, read with 35, read with 38.
10 has to say it. That is what I am submitting. 10 has to say it. 10 doesn't say it.
Yeah, because 11 to 19.
Here,
11 to 18.
8.1 provides that concessional credit. 8.4 says unless you file that prescribed form, you won't get 8.1. 10 should say it.
Yes.
14 minutes. We are of the view that Rule 6B2 of the Central Sales Tax Karnataka rules, which provides for furnishing of original C form in order to claim the concessional rate of tax, is consistent with the provisions of the Central Sales Tax Act, and there is no conflict between the provisions of Rules 12.2 and 3 of the Central Sales Tax rules and Rule 6B2 of the Central Sales Tax Karnataka rules, as contended by the appellant. Rule 12 of the rules is intended to prevent misuse of C forms by unscrupulous and mischievous dealers and makes it obligatory for the dealer to furnish indemnity bond. In other words, in order to claim concessional rate, of tax, original C form has to be attached to the return as provided for under 6B2 of the Central Sales Tax Karnataka rules. It is not a mere formality or technicality, but it is intended to achieve the object of preventing the forms from being misused for the commission of fraud and collusion with a view to evade payment of taxes. In our opinion, 6B2, which is clear and categorically cannot be liberally construed, but it has to be construed strictly. We therefore hold that without producing the original C form as prescribed under 6B2 of the rules, appellant is not entitled to concessional rate of tax under subsection 4 of 8 of the Act. Your lordships may then come to yes, 18. In Kedarnath Jute Manufacturing Company, the question that arose in this case was whether under section 5.2.A.2 of the Bengal Finance Sales Tax Act, the furnishing of declaration forms issued by the purchasing dealer was a condition for claiming the exemption thereunder. The court held as under. 5.2.A.2 of the Act, in effect, exempts the specified turnover of dealer from sales tax. The provision prescribing the exemption shall therefore be strictly construed. Substantive clause gives the exemption and the proviso qualifies the substantive clause. In effect, the terms of subclause 2 will be exempted provided a declaration in the form prescribed is furnished. To put it in other words, a dealer cannot get the exemption unless he furnishes the declaration in the prescribed form. It is well settled that the effect of an accepting or qualifying proviso, according to the ordinary rules of construction, is to accept out of the preceding portion of the enactment or to qualify something enacted therein, but for which the proviso would be within it. Over the page. There is an understandable reason for the stringency of the provisions. The object of 5.2.A.2 of the Act and the rules made thereunder is self-evident. While they are obviously intended to give exemption to a dealer in respect of sales to registered dealers of specified classes of goods, it also speaks to prevent fraud and collusion in an attempt to evade tax. In the nature of things, in view of innumerable transactions that may be entered into between dealers, it is well nigh be impossible that the taxing authorities to ascertain in which case whether a dealer has sold the specified goods to another for the purposes mentioned section. Therefore, presumably, to achieve the twofold objective, namely prevention of fraud and facilitating administrative efficiency, the exemption is made subject to a condition that the person claiming the exemption shall furnish a declaration form in the manner prescribed in the section. Liberal constructions suggested will facilitate the commission of fraud and introduce administrative inconvenience, both of which the provisions of the said clause look to avoid. In Maharashtra versus so-and-so, the court, while construing the rule-making power of the central government, has observed as under. Central government has, in exercise of the power under section 13.1d, prescribed the form of declaration and the particulars to be contained in the declaration. A direction that there shall be a separate declaration in respect of each individual transaction may appropriately be made in exercise of power conferred under 13.1d. The state government is undoubtedly empowered to make rules under subsection 3, 4, 13, but the rules made by the state government must not be inconsistent, so and so. In a similar matter, CST versus Delhi Automobiles, the Delhi High Court has held that a production of a declaration form is a condition precedent for the availability of the concession. Bench has also held that these detailed provisions are intended as a measure of safeguard against possible misutilization of forms and also to ensure that the relief is not obtained by more than one selling dealer in respect of the same declaration form by using various parts of it differently. High Court further held that the essence of these rules and regulations is that a selling dealer is able to claim the benefit of concessional tax. He should be able to produce the original and duplicate issued by him by the purchasing dealer in the first instance, or the duplicate form, which will also contain these two portions of the form issued with the declaration subscribed to the purchasing dealer subsequent, so and so. Then, my lords, manganese is cited by the assessee and is distinguished. Your lordships may kindly come to para 25 straight away. The learned senior counsel of the appellant submitted that there is no suggestion anywhere that there is anything wrong with the genuineness of the transaction or any doubts as to the possession by the purchasing dealer of a certificate enabling the sellers to obtain the concessional rate of tax under Section 8 of the Act. Under these circumstances, authorities should not have taken a strict view in rejecting the claim for concessional rate of tax. At first sight, the argument of the learned counsel appearing for the appellant appears to be genuine and acceptable. But considering the mandatory nature of the provisions of the Act and rules, this court is called upon to decide the questions involved in the case. The provisions being mandatory, they should have been complied with. The appellant made no attempt to comply with Rule 12.3 till his claim was rejected by the assessing authority, having himself having made no attempt to comply with the mandatory provisions, he disentitled himself from getting a concessional rate. Even otherwise, in our view, it is a pure question of law as to the proper interpretation of the provisions of Central Sales Tax Registration and Turnover Rules, 1957, and 6B2 of the Central Sales Tax Karnataka Rules. In view of the decision of Delhi Automobiles, Kedarnath Manufacturing Company and decision of Delhi Automobiles, it is clear that these provisions have to be strictly construed. Unless there is strict compliance with the provisions of the statute, the assessee would not be entitled to concessional rate or tax. We are of the opinion that a liberal construction was not justified having regard to the scheme of the Act and rules in this regard, and if there was any hardship, it was for the legislature to take appropriate action to make suitable provisions in this regard. It is also settled rule of interpretation when the statute is penal in character, it must be strictly construed and followed. We must also realize that the section and the rules as a stand may conceivably cause hardship to an honest dealer. He may have lost the declaration form by pure accident, and yet he will be penalized for something which he is not responsible, but it is for the legislature or for the rulemaking authority to intervene to soften the rigor of the provisions, and it is not for this court to do so when the provisions are clear, categoric, and unambiguous. Select first, is it? I want to do Kothari sales first, no? Then answer sales. It was made to look as if Centum, infinite in the sequence, Infinite Builders, Centum, and Nandi constructions are some nature of divergence or exceptions. I will come to the cases under the Sales Tax Act, which according to me are not relevant. The provision itself is completely different. They don't also answer the question that the Supreme Court says now, that it may be inconvenient for you, but you comply with the manner, and it does not consider the issue of benefit concession. And 14, I'll show you, Lordships, my lords, it strictly says rebate. Now, I'll just cite about 3 judgments which have followed Centum, but Court of
our High Court?
Our High Court.
What Centum said, according to you?
Centum said, my lord, that return is mandatory. Claiming input tax credit in return is mandatory and needs to be done in a time-bound manner.
That is reiterated by other division benches.
Yes. Infinite Builders, Justice Shailendra Kumar's division bench judgment is in fact before Centum. The first judgment was infinite. Then it goes to Centum. Nandi Constructions goes a step further and says the primacy of returns is not limited to input tax alone. Any benefit, you will disentitle yourself if it is not there in the return. I will cite Nandi while closing, months.
In Kothari sales, which is the paragraph?
Your lordships may see 6, 7.
6 reproduces 10.
Yes. 7 reproduces 10, 4.
4.
I will read 7. Minute. Subsection 4 of 10 of the Act provides how the net tax is to be paid or refunded to be calculated. It provides the first condition to be fulfilled in the tax invoice or debit note or credit note in relation to a sale ought to have been issued in accordance with this section 29. Secondly, the return is to be filed as provided under 35(1), that is a return VAT 100. Within 20 days or 15 days after the return of the end of the preceding month, showing the input tax as well as the output tax and the credit which is claimed. However, if there are incorrect statements in the said return, an opportunity is given to the assessee to file a revised return in the prescribed form within a period of 6 months from the end of the relevant tax period, subject to permission being granted by the prescribed authority. If return is not filed within the aforesaid time, then the question of calculating the refund does not arise. In the instant case, admittedly, the returns for the period from April 2005 to instant case 2007 were only filed in January 16, 2010. In fact, the reason given for delay in filing such a return was that the assessee was a heart patient and he could not file the return in time. The law do not provide for continuation of delay for any such reasons. On the contrary, it prescribes the time limit within which these returns have to be filed if the assessee were to claim refund of input tax. Having regard to the language employed in Section 10.4 of the Act, the issuance of invoice, debit note, and credit note in accordance with 29 is mandatory, and in the said return filed, all the particulars which are necessary for claiming such refund has to be mentioned, and such return has to be filed within the time period prescribed. The court had an occasion to consider the same in the case of Karnataka versus Centum Industries Private Limited, so-and-so in STRP's number so-and-so, where after referring to the sections of 10 and 35 at paragraphs 9 and 11 following a sip.
Yes.
The next judgment, my lord, is of a division bench of my lords Justice Jayant Patel and Justice Arvind Kumar.
Mr. Naganand may not reach today. We are in the mid of some important matter. Some date you can choose, whichever date you will inform. Let your advocates on record. Both sides may inform and court officer will give one. Yes. This is Bhuratnam.
Bhuratnam.
Paragraph.
He claims, my lord, he claims that I have paid purchase tax under 3(2) of the VAT Act on the purchase of sand, and can I be disentitled to it? Your lordship may see paragraph 4. Questions are in 3. The contention raised by the learned counsel for the petitioner is that the decision of the court in the case of state of Karnataka versus Centum Industries Private Limited reported in so-and-so is carried before the apex court, and therefore it could not be stated by the tribunal that the issue is already concluded. It is submitted that it is true, as per the requirement of 35(4), the revised return is required to be filed within a period of 6 months. But the contention of the learned counsel for the petitioner is that the outer limit of providing of 6 months is only a procedural aspect, and if by other evidence it is satisfactorily demonstrated that the petitioner is entitled for input tax credit, the same should be entertained at any point in time, namely even after the period is over and even if no revised return is filed. Your lordships may leave.
Para 7.
The aforesaid section makes it clear that if there is any discovery of any omissions or incorrect statements other than as a result of.
He also refers to Centum.
Yes. Yes, ma'am. And then paragraph 8 at the bottom of the page,
where he says he has not filed revised return at all.
Yes. And then he negates the contention that something is pending before the Supreme Court.
Then we continue tomorrow. Another half an hour.
Maybe 15-20 minutes.
Then because he also has to answer that. No?
I was saying the table tennis match where it ends, but we are in your lordship.
In fact, requested my learned friend to give these decisions before lunch so that I could have finished while I was addressing the argument.
But right now, even I have not finished.
Anyway,
as long as I get an opportunity.
ಅವಸರ ಮಾಡೋಂಗಿಲ್ಲ ಇದು. ಇಲ್ಲ ಇದರ ಕಾನ್ಸಿಕ್ವೆನ್ಸಸ್ ಏನೇನಿದೆ ಹಿಂಗ್ ಮಾಡಿದ್ರೆ ಒಂದ್ ರೀತಿ ಡೀಲರ್ಸ್ಗೆಲ್ಲ ಅನ್ಯಾಯ ಆಗ್ಬಿಡ್ತದೆ. ನಾವು ಆನೆಸ್ಟ್ಲಿ ಕೊಟ್ಟಿರ್ತೀವಿ, ನಮ್ಗೆ ಇನ್ನೊಂದ್ ಸರಿ ಕೊಡಿ ಅಂತ ಅನ್ಕೊಂಡು ಹೇಳಿದ್ರೆ ಅದು ಒಂದು. ಈ ರೀತಿ ನಾವು ಬಿಟ್ರೆ ಈ ಲೈನ್ ಆಫ್ ಜಡ್ಜ್ಮೆಂಟ್ಸ್ ಇದೆ, ಎಲ್ಲವೂ ಸೆಂಟಮ್ಗೆ ರೆಫರ್ ಮಾಡ್ತಾರೆ.
Infinite predates centum and Nandi is the landmark, my lord. I'll come back to Infinite and Nandi.
Morning. Further hearing. Heard in part. Heard further in part. Both learned senior advocate appearing for the assessee and the learned AGA appearing for the revision, the revenue. Ad ಮೊದಲಿಗೆ revenue, ಆಮೇಲೆ assessee. Okay, 29 ತೆಗಿತಾರೆ ಬರುತ್ತೆ. 29.
Yes, of course.
29 and
connected,
33 together we are.
Because there are different assessment here. Facts are the
That's
same.
all,
Like I
same.
pointed out, 1 year is already decided by this one.
Okay.
But the company matter not may have to be treated as part head, my lord. I understand there may be a change of roster. I don't know, my lord, if it is so, my lord, then it may go before the normal roster.
ನಾಳೆ ಹಾಕೊಂಬೋಣ. Tomorrow we'll have this matter. ನಾಳೆ ಹಾಕೊಂಬೋಣ. ಅಲ್ವಾ? ಅದೇ ಪಾರ್ಟೆಡ್ ಏನದು ಆಲ್ಮೋಸ್ಟ್ ಹಿಯರಿಂಗ್ ಆಗಿ ಹೋಗಿ
ಅದೇ ಮುಗ್ದೋಗಿದೆ ಅದಕ್ಕೇನೇನೆ.
ಇದು ಫಾರ್ ಫರ್ದರ್ ಹಿಯರಿಂಗ್ ಅಂತ.
I think it was coming for further hearing, but today for some reason it has come.
Orders
ಇಲ್ಲ, ಯಾವಾಗ ಫರ್ದರ್ ಹಿಯರಿಂಗ್ ಇತ್ತದು, ಅದು why it has come like that, I do not know.
ಆರ್ಡರ್ಸ್ ಅಂತ ಬರ್ತಾ ಇದೆ ಅದಕ್ಕೆ.
How's memo is there, I think.
Have you objection for treating it as?
There was an amendment to be carried out. There is an office objection, so it is come under orders.
Okay. But see, post this matter in the first week of March 2025 for further hearing. Amendment ಏನು ಯಾರು ಮಾಡೋದಿತ್ತು? ಅದೇನೋ ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡೋದು ಅಂತ ನೋಡ್ರಿ.
I have already carried out, my lord.
ಮಾಡಿದ
There is some office objections raised on that.
ಏನು
We'll attend to that, my lord. If there's any more objection.
office objections, if any, to be in the meanwhile attended to. Okay. 6th of March.
I think
6th of March. Okay.
2:30 ನಾ ಅಥವಾ ಹೇಗೆ ಅಂತ.
ಅಲ್ಲೇ ನೋ ಇಶ್ಯೂ. 2:30 ಅಂತ ಹಾಕೊಂಡ್ಬಿಡಿ ಅಷ್ಟೇ. Okay. All right. Okay. Thank you.
Thank you.
This also
Okay,
is it's not a concession and all that.
It will be in the
Once
second
we are
filing
sure
or
about it.
Skip this. No, I have not yet come to answer. This has to be treated. No.